Judge, it's Faith. Can you hear me?
Yes. Good afternoon, Metha.
Good afternoon, Judge. I confirm that we have the claimant's counsel on the line, Mr. Patrick Malone and Mr. Alexander Burrad on behalf of the defendant.
Yes, I can see them.
Good morning, Judge.
Good morning, both of you.
Morning, Your Honor.
Thank you, Judge. I would like to begin by reading out a statement, please.
Yes, do.
Yes, thank you, Judge. The trial is in the matter of TCD 003-2019 before Justice Sir Richard Field and is being held by way of video conference. Any orders or directions made after or during the course of this trial will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi & Company. Lead counsel is Patrick Malone. The defendant is represented by Ibrahim Al-Banna Advocates and Legal Consultants. Lead counsel is Alexander Burrad.
Yes, thank you very much. Yes, well, I think it's you to begin, Mr. Malone.
Yes, thank you very much.
Underway.
Thank you very much, Judge. Before I give my 6-minute introduction, there are a few housekeeping matters. I don't know whether you wish us to mention them now or perhaps later in the day.
Well, if you can deal with them briefly, let's deal with them now.
Thank you. The first is in relation to RDC 35.29 in relation to the status of the documents in the bundle. And the parties are agreed that the documents should be treated as authentic within the meaning of Subrule 2.
Yes.
But that they shouldn't be evidence of fact stated in them within the meaning of Subrule 3.
Yes.
So that's RDC 3529, agreement on Subrule 2.
Yeah.
The second matter is in relation to, there are very, very few documents in the bundle that are translations from Arabic into English, and they are the judgments of the onshore court, which are included in the bundle. And there's agreement on those translations.
Good.
And then the third aspect is also a matter of agreement. There will be uploaded shortly, if not already done, a further minute of a program meeting dated the 11th of September 2019 at the request of the defendant, that we have agreed to that going into the trial bundle today.
Yes.
And then the fourth matter is a matter upon which I don't believe there is agreement. On the 16th of September, my client Abu Qasim Akprajiev swore a very brief second witness statement, simply appending and exhibiting the invoices and payment confirmation of the costs incurred by my client in the onshore Dubai court proceedings.
Yes.
That's a short witness statement of 7 paragraphs. It was provided to the defendant on the same day. There was a short exhibit of that material. We didn't upload it to the bundle because we thought we would need your permission. We did ask the other side if we did file it online on the system, but not in the trial bundle.
Yes.
And it's my respectful request that witness statement be admitted in due course.
Yes. Well, that's the only matter in contention.
Yes.
Well, Mr. Burrad, what do you say about this second witness statement?
Yes, Your Honor, I don't have instructions to agree to it being added. I note that the original witness statement deadline was the 29th of April. There was a deadline for supplementary witness statements on the 20th of May. On a brief review of the, so as I understand it, the purpose of the witness statement is to adduce additional evidence of the alleged legal costs that Al-Tamimi incurred in relation to the Dubai court proceedings. The last invoice date that I can see on there is the 30th of April, 2021. As a result, I'm not sure why this witness statement is only being served at this stage, when it appears that it would have been possible to have served it at least at the date of the supplementary witness statements, or even if it was to be later than that, certainly earlier than a week before the case. The part of the issue that arises is that it adduces additional quantum evidence, and the quantum experts have not had an opportunity to review the same and comment in their reports on the same.
But as I understand it, Mr. Burrell, I haven't seen the witness statement. It sets out the costs incurred by the claimant in respect of the onshore proceedings. That's it.
Yes, Your Honour, it does.
Let's wait and see how we go. All right. It's not in compliance with the timetable, but given its nature, these costs were either incurred or not. And you may not agree. You may not agree with the contents. But nonetheless, I think this witness statement ought to come in and you can challenge it. And if you need more time in the circumstances, you can apply for it.
I understand. Thank you very much, Your Honour.
Right.
Thank you.
Well, let's get on with it.
Thank you very much, Your Honour. In very briefly, to outline the nature of the case, this is a breach of contract claim in respect of a construction contract. And the project was for the completion of a tower building in the Al Fujain area of Dubai. It's a mid-town, mid-market project, which at this particular time was a sweet spot in the market for the development of residential units. And my client, Panther, is an experienced and successful developer of residential properties and is particularly focused, and all of its projects are in the sales market, including the off-plan sales market rather than the rental market. As a result of the delay that is the subject of these proceedings, unusually and uniquely, my client was compelled in the circumstances of 2020 and the delay arising to go to the rental market. And the delays that are the subject of the proceedings, we say, were the responsibility of the defendant, MESC, who had a duty to complete in time. And there were multiple unremedied and cumulative delays that afflicted this project, which on our case are and were at all times the responsibility of MESC as the contractor of the project. In the course of the project, there were 3 extension of time applications. Those related to 12 delay events, which were all adjudicated upon. In fact, there were some of them overlapped within the 3 requests. They were all adjudicated upon by the engineer, we say lawfully and rationally, and we rely on our expert evidence in relation to that. That led to events in June and July of 2019 when the 3rd extension of time request had been rejected. There was still cumulative and ongoing delay and unsatisfactory progress on site. And that led on the 6th of July 2019 to a threat by MESC to suspend works because it was unhappy with how my client was insisting upon its contractual rights. And that led to a process in July 2019 where MESC recommitted to providing a realistic program for the completion of the project. And the focus shifted then to achieving that. And to that end, MESC provided a Memorandum of Understanding, and the key features of that memo were 3 elements. One was that we would waive our entitlement to delay damages under the contract. Second was that we would waive the engineer fees, which had been additionally incurred, and that a program would be agreed with a new completion date. The actual completion date under the project was the 18th of December 2018. So the project was already, by July 2019, 7 months overdue. And then, despite this commitment that was made by MESC, in fact, those delays became worse over the period from July to October 2019. There were troubles with its subcontractors that had attempted to blame on my client. And at this stage, there were over 300 days of delay on the project. We were entitled under the contract to terminate immediately after 99 days, because by that stage the delay damages had been exhausted. But in any event, on the 27th of October 2019, at a meeting between the parties, a threat was made again explicitly by MESC and its representative, Mr. Al-Kurdi.
Oh, excuse me, just a moment. The MOU, I mean, was that ever signed and became a binding arrangement?
No. And
the set of proposals that was put forward by MESC, which your clients rejected.
Exactly.
Yeah.
And at that meeting on the 27th of October, MESC explicitly made clear that unless my client agreed to the MOU, they would cease work and stop work. And that threat was made absolutely crystal clear in minutes of the meetings that they sought to amend, and by their conduct in the coming days, which led eventually to them suspending works on site on the 3rd of November 2019. We had cashed the bonds by letters dated the 28th of October 2019. They were on-demand bonds, which by reason of their terms, we were clearly entitled to encash at that stage.
Yes.
But the extreme response of MESC was to suspend works. At this stage, that we were left with no choice but to terminate. The repudiatory character of the conduct was clear. As we've said in our skeleton argument, it included also an anticipatory element, because we were told that if it took 10 years to persuade us to agree to their MOU, that's what would be done. There was absolutely no question that we were being told that no work would be carried on unless we agreed to their unilateral terms and varied the contract. The last part of the project, of course, is a crucial part of any construction project. And MESC make the case, oh, well, there was about 90% of the project complete at this stage, and they tried to say that my client was acting in bad faith at this point. But of course, this was the difference to my client of success and failure in the project. Delays of this kind afflicting the end of the project, typically the most difficult part of the project, would have jeopardized it. And it was precisely because their extreme conduct put the project in peril and jeopardized the entire venture that my client took the action that it did. But of course,
Sorry to interrupt.
Yes.
Sorry to interrupt. Mr. Allen, one of your experts, your expert on delay, he does agree to certain of the defendants' claims for an extension. Now, I haven't totted it up.
Yes.
I don't know whether you can tell me right now. How many days does your expert accept the completion date should be extended by?
Very good. I would have included that. For time reasons, I didn't include it, but I can tell you, of course. There was a period between the planned date of receipt of the drawings, the main drawings for the project, was the 13th of August 2017. The actual last receipt of the important drawings was on the 26th of October 2017. On our calculations, that's 74 days. By some computer calculation of MESC, it's 76 days. So depending on which you calculate it by, it's either 74 or 76 days. But can I say?
Yes, go on.
Can I say it's our case? And I think it is reflected in Mr. Allen's report, also in his conclusions on the allocation of responsibility and the impact on completion date, that 74 days did not affect the completion date. It was not a critical delay. And the reason for that is because the actual baseline program for the project commenced on the 4th of October 2017. And therefore, the float period, I think Your Honour, you're familiar with the float in construction contracts. It's a cushion, effectively, for both parties. So as a result of the float, the there was in fact some activity on site in September, putting in porta cabins and things like that. And October there was excavation began.
Sorry to,
but there was not an impact on the critical delay.
We are short of time. Are you saying that in fact you do not accept any extensions of time as advocated by the defendant? Have I misread Mr. Allen's reports? Because I read him to be saying, in certain of the circumstances, that he would agree that certain extensions in numbers of days were extensions to which the defendant was entitled to. Are you saying that at the end of the day, no extensions are agreed?
That I am, and for a few different reasons. One is the one I just mentioned, that it didn't have an impact on the completion date,
yes,
which is the criterion. The second is that that particular delay, the 74-day delay, was never the subject of any extension of time application. And under clause 20.1 of the contract, that is the end of it. And of course, we say that about a number of other complaints on delay that have been raised in the proceedings.
I see. Thank you very much.
Thank you. I probably don't need to finish by talking about the impact on my client, but there were, I think you will have read in the pleadings and the evidence and the skeletons, that these included a number of post-termination attempts to frustrate the handover of the project to my client. And notwithstanding that, and it's a testament to the determination and skill of my client that it managed to complete the project by the 1st of May 2020. And it thereafter took, on our case, very speedy measures to make sure that its losses were the least that they could suffer in the circumstances, and they mitigated very well the damage that was done to them. But notwithstanding, they lost a significant opportunity, which was the original business plan, to go to the market at the time
yes,
when they would have yielded a far greater profit.
Yes. Well, thank you very much indeed.
Thank you, Judge.
Yes, Mr. Burrows.
Thank you, Your Honour. I'm a learned friend of Panther. I've tried to paint a story of MESC as an incompetent contractor responsible for a significant delay and responsible for a litany of poor behaviour on the project. But this synopsis ignores the realities of a construction site. The issues that Panther have complained of are in fact regular everyday issues on many sites in the UAE. Importantly, in this regard, Panther have failed to demonstrate that any of these issues actually cause delay to the project. Indeed, Panther's own delay expert has not conducted any comprehensive delay analysis, nor established a critical path. This will be further explored in expert evidence, but it is MESC's case that in fact, the vast majority of the delay was not caused by MESC, and indeed is a result of events for which it is entitled to an EOT. Now, the termination is ultimately what has led us to this litigation, but the reality of what happened at East 40 is slightly different to the account that Panther give. And it's MESC's case that it is a result of Panther's actions from the summer of 2019 onwards as to why this project spiraled towards termination. In particular, between July and September in 2019, the engineer had certified almost 3 million dirhams in payments, yet Panther only paid 450,000. So over these 3 months alone, there's over 2.5 million dirhams of certified payments that went unpaid. It's MESC's case that Panther was preparing to terminate even at this stage. Panther's strategy becomes clearer when in October it encashed bonds worth over 5 million dirhams. Now, this was before the alleged abandonment. Now, whilst Panther may allege that it terminated due to the abandonment or otherwise, it is MESC's case that the reality is different, and that Panther had been preparing to do this, withholding sums and encashing bonds. Now, Your Honour may be familiar with the UAE construction sector, but unfortunately, this is not an uncommon occurrence. When a project almost reaches completion, it's frequently occurs that an employer will withhold sums, encash bonds, and terminate the project. As once a project is terminated, the employer can still hold on to the retention. So this way, an employer holds all of the cash, whilst the contractor is out of pocket, placing the employer in a significantly stronger position when they can allege significant costs of completion and/or delay damages, as has happened in this case, and squeeze a contractor into one-sided settlements. Part of the problem for Panther is that it did not execute its termination effectively. Panther purported to effect immediate termination, meaning it is restricted to immediate termination grounds. In reality, it only relied upon one immediate termination ground in its notice, the exhaustion of liquidated damages, and that, of course, will be the subject of the expert evidence later in this hearing. Whilst it may now try and claim to have terminated on a number of other grounds, many of these were never registered in the termination notice. As such, in reality, there is only one ground that the court needs to focus on. Panther's inappropriate conduct and strategy at the end of this project and during these proceedings can be further illustrated by a review of the main heads of loss claimed by both parties. Now, the most significant of which, my learned friend has already intimated, is Panther's claim for loss of opportunity. Panther claims over 17 million dirhams, alleging it had planned to sell its units in an off-plan strategy in November 2017. Now, this allegation will be explored in both factual and expert evidence, but in reality, this evidence may be largely irrelevant. Now, this is a legal point which will be addressed further in closing submissions, but from what I understood from my learned friend's skeleton, is that Panther concede that liquidated damages apply before termination. Now, if that concession is correct, it's unclear how Panther can still be pursuing a loss of opportunity claim for the alleged failure to sell off plan in November 2017. These are events before termination and as such are restricted to liquidated damages. A similar point is made in relation to Panther's other delay-related claims prior to termination, namely company overheads and others. It cannot claim these if it is restricted to liquidated damages before termination. The fact that Panther is still trying to claim these very significant sums in addition to liquidated damages demonstrates their inappropriate approach to this project and proceedings, and indeed is a clear example of an attempt at double recovery. The other two major claims or major items of claim in these proceedings are MESC's counterclaim for valuation of works done and Panther's claim for the cost of the completed works. Now, these have been dealt with extensively within the expert evidence, and as will be explored in depth both during witness and expert evidence, it's MESC's position that the evidence relied upon by Panther is highly questionable, and the fact that Panther places reliance on such unreliable evidence demonstrates its further inappropriate conduct in these proceedings. So unless I can assist any further.
Well, I did have a point I wanted to raise with you. The FEDIC terms set out basic preconditions for the determination of an EOT. And on a number of occasions, the engineer dismissed a claim for an extension for failure to have complied with those conditions. Now, you cite a decision of a judge sitting in the Northern Territories of Australia. And I've read that judgment. And at the moment, I have to tell you, I have great difficulty in accepting its correctness. Just to take an analogous situation. Often in charter parties, there are strict conditions as to the service of notice of claims in respect of extra hire and the like. And even if what lies behind the claim is a failure by one of the parties to the charter party, if those terms are not complied with, the precondition operates and the claim fails. Now, I've read this decision, and can you tell me, has it had any broad acceptance in the common law world and in the construction law of the Commonwealth in general, and in particular in the United Kingdom?
As far as I understand it, I'm not sure that it has. I don't think it's necessarily its status is not entirely disregarded, and it's referenced within the construction law textbooks. But it's certainly not, as far as I'm aware, it's certainly not been widely accepted, if that is necessary.
Well, you can, the judge seems to have proceeded on the basis that it would be all frightfully wrong if a delay was caused by the conduct of the employer, but no claim could be made in respect of it because of a failure to give notice within particular time or whatever the preconditions were. And that seems entirely to ignore, first of all, that the parties have agreed to these preconditions and that the preconditions have a freestanding justification so that parties know where they stand and there's some procedural regulation as to the making of claims. And so I'm just waving a little red flag, if I may, to say that I'm going to take a deal of persuading that one can ignore a failure to comply with preconditions for the making of an EOT claim on the basis that it would be unfair because, in fact, such delay was caused by the employer rather than by the contractor. We can come back to that if necessary.
I understand, Your Honour, and your point is noted. For the avoidance of doubt, it is MESC's case that they have submitted notices in fact, in the vast majority of the delay events which did cause or are alleged to have caused critical delay.
Yes. And
we can address those in closing.
Yes, well, they may well surface as issues in the issues of fact in the claims.
Indeed. And the other thing, very briefly, Your Honour, is there's a slight distinguishing of the 2 points in relation to the service of notice. I think it's accepted that if there is a failure to serve notice, there isn't an entitlement to the EOT, but it's pursuant to this the Gaymark case that simply because you're not granted the EOT does not mean that it would be just to impose liquidated damages. So it's the imposition of liquidated damages, which is the point that's argued that doesn't apply if there is.
At the moment, I don't understand that. If two parties have agreed that a claim for an extension has to comply with a set of procedural conditions, and the contract makes clear that if those conditions are not complied with, the claim will be an ineffective claim. I'm afraid I cannot see how a claim that was in breach of those conditions can be made. Otherwise, these conditions are not worth the paper they're written on.
Well, as I understand it, Your Honour, it would prevent the granting of an EOT, which would mean that there wouldn't be prolongation costs. But it would also mean that if there was an event which would normally grant an EOT, but for the issuance of a notice, it would mean liquidated damages wouldn't apply. So there would still be a beneficial effect for the employer.
Well, why wouldn't liquidated damages apply?
I think the point is that it's part of an extension of the prevention principle, and indeed the equitable point that an employer shouldn't benefit from its own actions if it was the cause of the delay. As in this case, if the employer was the cause of the delay, but simply because of a failure to serve notice by the contractor, the employer would be receiving liquidated damages as a benefit as a result of its own breach of the contract. So that's the justification for the argument, as I understand it, Your Honour. But there is a secondary argument in relation to this as well, Your Honour. So that's the main thrust.
Yes, I follow. I follow what you say. Yes, and what's the secondary element?
The secondary element is even if Panther is entitled to pursue general damages before termination, contrary to what I discussed in my oath earlier.
Yes.
That an employer would not be entitled to pursue general damages as a result of an employer delay event simply because of a contractor failure to serve notice. And this is a causation point which was set out in my skeleton, namely that the contractor will have proven that the delay was not caused by it. And therefore, I think you understand the point, Your Honour. Thank you.
Yeah. Sorry, thank you very much. Well, then we move to the evidence. I think.
Excuse me, I'm on mute. Thank you, Judge.
You're not on mute anymore. Good.
Thank you.
Yes.
The first witness
is
Mr. Mustafa Resk, and
yes.
he's next door, and
yes.
he should be coming online any minute. And
right.
he has a Quran, and is ready to have the oath administered.
Right. Very good.
Good afternoon, Judge. Good afternoon, everybody.
I'd like to be able to say, there's the witness, Mr. Resk. Good afternoon to you.
Good afternoon, Judge.
You're about to give evidence, and it will have been explained to you that in this court, evidence is given on oath. It can be a religious oath. It can be a secular oath. The court makes no distinction in terms of the value of the oath, whether it's religious or whether it is secular. I understand you'd like to take an oath on the Holy Book of the Quran.
Yes, correct.
Now, will you carefully listen to what I'm going to say to you? Do you solemnly and sincerely swear on the Holy Book of the Quran that the evidence you are going to give in these proceedings is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You do. Thank you very much. Yes, Mr. Dillon Malone.
Sorry, Your Honour, I apologise to interrupt. It was something I meant to raise in housekeeping earlier on. I just wanted to clarify, as far as I understand it, there's no restrictions on witnesses watching other witnesses, watching other evidence before them in these proceedings.
Well, it would require an order for that to be operating, and no such order has been sought. So.
Indeed. No, that was my understanding, Your Honour.
Yes.
I just wanted to clarify that point. Thank you very much.
Good.
Thank you, and likewise, that was our understanding. Mr. Resk, thank you very much. I think you have in front of you a clean copy of your witness statement.
Yes, I have.
And can I ask you please to turn to the final page of that witness statement?
I did.
Yes, and can you please confirm that that signature is your signature?
Yes, it's my signature.
And can you please confirm that this is your evidence in this case?
Yes, it's my evidence.
And now, are there any matters that you want to correct in your witness statement?
No, not at all.
Are there any matters you wish to clarify for the benefit of the court?
No, not at all.
Well, thank you very much. I think if you could please answer the questions of Mr. Burrell.
Sure.
Yes, Mr. Burrell.
Thank you, Your Honour. Mr. Resk, I just wanted to take you to your witness statement. So it's on the first page, and for the benefit of the court, that's at C1.
Yes, actually, I've got this in hard copy.
Okay, thank you. Mr. Resk, firstly, I just wanted to clarify what your job role is. You state you're currently a project director at Town X, is that correct?
Yes, correct.
And Town X are contracted to Panther. What are they contracted to do for Panther?
We are The relation between Panther and Townex can be addressed by Mr. Akbarjef. He's the manager, and he can address the relation between two companies. But our duties, we were carrying out the project management for the project.
So Townex are a project management consultancy. Is that what you're suggesting?
We are a real estate company. Townex Real Estate. We are a real estate company, but
Right.
we are following up the project for Panther.
So
Well,
you're
what are
really
you doing? What are you doing by following up the project? Give me some flavour of what you're
We are attending the progress meetings. We are going with the engineer and the contractor for the site walks. We are following up with them for the approvals. We are acting as a Panther to facilitate the approvals and the site activities.
And you're doing that on behalf of Panther.
Yes, exactly.
Thank you.
And you state that you held this position since November 2018, and that you also held the position of project manager with Naga from June 2018 until completion. Is that correct?
Yes, correct.
So from November 18 until May 2020, you held two job positions, both with Naga and with Townex.
Yeah, from June 18, I started as engineer in the project with Naga, but I'm working with Naga since 2017. But only I start as an engineer for for Jan project only on June 18.
To clarify, though, you don't work for Panther itself, do you? You're an employee of other companies.
I'm working for Townex.
And you are a witness during the project only, is that correct? So your personal knowledge in this case is limited to what happened during the project.
Exactly, it's personal knowledge started from June 18.
Now, I just want to go to a couple of paragraphs in your witness statement. I'll keep it brief in relation to this. If you go to, it says page 4 of your statement, paragraph 17 and 18. Now, in these paragraphs, so I'll just wait until we're all there.
Which paragraph?
So paragraph 17, and you state here that MESC unsuccessfully sought to contest the jurisdiction. You're advised that MESC has unequivocally submitted to the jurisdiction. You then say in paragraph 18, MESC continues to sow confusion in one of its appeals before the Dubai Court of Appeal, which is pending. Now, do you have personal knowledge of this background?
Yes, I do. I have a personal knowledge about that.
Why do you have a personal knowledge of this if you're not an employee of Panther?
We are getting all the notices from Dubai court related to the case. So when MESC started the cases in Dubai court, we have received the notices and we already look into it. So we know that MESC already started cases in Dubai court against Panther.
So is part of your job role with Townex to deal with these cases? Is that correct?
It's not a part of my job to deal with the cases. However, if there is any technical part need assistance for that, I'm doing it.
Okay, well, briefly, we'll just go on to paragraph 248. So I think it's page 8 of your, paragraph 37, page 8 of your witness statement. Just whilst we're on this point.
Okay.
So paragraph 37, and you state here, further, given the true facts and record of which MESC is fully aware, Panther believes it to be a fair inference that these allegations have been concocted by MESC for tactical reasons. Now, again, you're not an employee of Panther, so why are you giving evidence on behalf of Panther here?
I'm given the statement, what I from my knowledge, from the document which I have, MESC started the cases in Dubai court just to hold the project and stop the taking over by Panther to continue the work. This is why I have the knowledge of the cases.
But it appears from this paragraph that you're saying Panther believes it. I mean, it appears that you're giving evidence on behalf of Panther. Would you agree with that?
Yes, exactly. But Panther and Townex, we are acting on behalf of Panther. So when I'm giving the statement, I'm giving the statement as a Panther.
You're giving your statement as if it's on behalf of Panther.
Yes.
Well, strictly speaking, what he says, what he's relating is Panther's belief. That's what he's relating.
Yes.
I don't think you need to take too much time.
No.
To paragraph 37. That's not going to weigh very heavy in the scales at all.
No, I understand you. I'm moving on in any event.
Yeah.
Now I'll come back to your role with NAGA, where you're a project manager. Now, I've seen some of the correspondence in this matter was issued by yourself. Is that correct?
Exactly.
How big was the team at NAGA on this project?
If you need to name the roles, I can tell you. I was a project manager.
I just need like a number. I don't need all of the
number. Six persons from the engineers are involved in the project.
How closely were you aware of all of the various determinations made by NAGA during this project?
Technically, we have a planner who was doing the evaluation based on the submitted document, the determination itself. We are reviewing his evaluation for releasing to the contractor. But we have a technical person in NAGA who were doing the evaluation based on the baseline, based on the provided document from the contractor.
Okay, I don't just mean the EOT determinations here. I mean a lot of the various determinations. But are you saying that you were aware or you have knowledge of these various different determinations? Is that correct?
Yes, correct.
If you go to paragraph, so page 4 of your statement, and it's paragraph 20 to 23. In particular 20, 22 and 23.
Okay.
So yeah, page 4 to 5. Now you discuss here the contract, and in particular, you discuss the various different terms of the contract, which MESC agreed. So would it be right to say that you're familiar with the terms of the contract?
Yes, exactly. I'm familiar with that.
And as part of your position with NAGA, you would sometimes have to implement the terms of the contract. Is that correct?
Yes, correct, definitely.
For example, you'd have to follow the terms of the contract when determinations were being issued. Is that correct?
Yes, we are applying the contract, the terms of contract, the particular or the general terms of contract. We are following it strictly.
Now, what I wanted to discuss is what happened after termination. So Panther effected termination on the 6th of November. Following termination, the engineer has certain responsibilities, don't they? Would you agree with that?
Yes, I agree with that.
And it's going to take you to, in the bundle, it's at bundle B, document 3. And then it's page 63 of this document. So you can do Control F and 63.
To slow down a little bit. Bundle B is the contract and the guarantee, yes?
Bundle B, yes, correct.
And can you give me an idea of which?
It's document 3, Your Honour.
Document 3, okay.
Yes, document 3.
In fact, I already have that on my screen.
And then if
the contract for construction, is that
correct?
It?
These are the general terms.
The general terms, yeah.
Yeah, and then if you do a Control F for 63, and you'll get to page 63 of 129, and that'll take you to the relevant page.
Oh, no, wait a moment. The case lines, it's find.
I found, because there's 2 page references generally. There's the bold page reference in the top right, but then there's a page reference at the top, which is the page reference for that specific document. So this would be page 63 of 129. And I found that when preparing, often when you're trying to do a Control F search, the bold numbers don't come up, but the ones at the very top do. So I'm going to try and keep my references.
Well, just bear in mind that some of us have to use the case line methodology. Now, what am I putting in? I'm putting in B and then the page. That's how I would do it.
So the page is 125 in the top right.
Let me put B in first, B, and then 125. Let's see what happens. Nothing. That's not very helpful.
Excuse me. I think it may be page 125 of the case lines bundle.
Yes, indeed it is. It's 125 of the case lines bundle, and it's 63 of the page 63 of 129.
Page 125 of the case line bundle.
Correct.
Just give me a minute. What's the quickest way of going to that using case lines?
I found
125, is it, or what?
I found, Your Honour, that at the very when you first click onto the document, I found the quickest way of getting to it is to do a Control and F search, and then to put in the number of the page. So if you see at the top of every page, it says page 1 of 129. I found that if you do a Control F for that relevant page and then go through the findings from the Control F search until you get to that page, because usually that'll get you there within a few moments. Whereas when I tried to do a Control F for the 125, because it's not loaded yet, or because that page hasn't loaded yet, it doesn't come up unless you scroll to it. So I found
I'm now at 125, that number being in the top right-hand corner.
Correct.
And I'm where we should be now.
Yes, you are, Your Honour.
Okay, well, let's carry on. Thank you very much, Mr. Burrow.
Thank you, Your Honour. Your Honour, it might be useful to, because I'll have various page references through the evidence. I was wondering if there might be a way of having a common approach to it, so that we can get to the documents as
well. I've just recently done a DIFC trial using case lines, and the way we went to particular documents was to put in the alphabetical signification, A, B, C, D, and then to put in the number with a hyphen in between, and up would come the relevant page, and it was very straightforward, and it worked very well. It didn't work just now. Anyway, look,
yes,
let's see
I think I may be able to assist later.
Okay.
It is quite simple on the case lines. It's just the number, not the letter. And no hyphen. Just the number will bring you straight to the page.
Just the number, and it'll take
on the case lines. Yeah.
Okay. Thank you very much. Anyway, we're there now. 125. Carry on, Mr. Burrow.
Yes, thank you. So what I'm interested in here, Mr. Rezek, is clause 15.3. And now I'm going to clarify that there are 2 minor amendments to this clause. In particular, the phrase in the first line under subclause 15.2 is deleted, and it's inserted with "of the contract." And then at the end of the paragraph, there's an addition which says engineer shall also agree or determine the cost to complete the works. And now, for the benefit of the court, as a page reference, that's on page 226, where the I'm not going to go to it now, but they're two minor amendments, so I'm not going to put an unfair question. But the remainder of it is not amended. And the question that I have for you, Mr. Rezik, is what this clause provides is that it says, as soon as practicable after a notice of termination, the engineer shall proceed in accordance with subclause 3.5 to agree or determine the value of the works. So would you agree that after the termination notice, the engineer has to value the works and the cost to complete in accordance with clause 3.5? Would you agree with that?
Yeah, definitely, I agree with that.
And would you agree that determining the value of the work done at termination is a very important task?
For sure.
And in the context of termination, especially where the parties are effectively in a dispute, would you agree that it's very important that the formal process to assess the work done is conducted properly, independently, and in accordance with the terms of the contract? Would you agree with that?
Yeah, I agree with that.
Now, let's just go to clause 3.5. So it's within the same document, and it's page 88.
Yes, but Mr. Dillon Malone, it works, just as you suggested. I'm right there, page 88. Thank you.
There we are. Excellent. Well, that should make things slightly smoother. So we set out here at clause 3.5. And now, again, just so that this isn't an unfair question, there is an addition of a 7-day period for reaching the agreement. So at the end of that first sentence on the third line, it says in an endeavour to reach an agreement in a period of 7 days, or within a period of 7 days. But otherwise, that first paragraph of 3.5 is not amended. Now, having regard to what we just discussed in relation to clause 15.3, which is that evaluation was required to be done in relation to both the value of the works done and the cost to complete, in accordance with this provision, we can see here, so it says whenever these conditions provide that they should proceed in accordance with clause 3.5, the engineer shall consult with each party, and if an agreement is not reached, the engineer shall make a fair determination in accordance with the contracts and taking due regard of all the circumstances. And then in the second paragraph there, the engineer shall give notice to both parties of each agreement or determination with supporting particulars. So to summarise, under this paragraph, would you agree, Mr. Rezik, that after termination, the engineer is, 1, to consult with each party to endeavour to reach an agreement, 2, if no agreement reached, issue a fair determination, and 3, give notice to the parties of that determination with supporting particulars? Would you agree with that?
Yes, I agree with that.
Would you agree that in this case, NAGA did not comply with any of these obligations in respect?
They have complied. They have complied. During November and December, NAGA, first of all, after the termination, they sent a notice to MESC to attend the site for the final evaluation. Simply the next day, MESC sent the reply letter to engineer notice they will not attend the site. The engineer has to proceed with the evaluation. They reject to attend the site. Based on that, the engineer, he prepares the evaluation, which already shared for all the claims, which already shared with all parties.
So you say that NAGA prepared evaluation, which they shared with all
they
parties.
did.
Could you clarify where the evidence of the sharing of that valuation is?
There is correspondence. There is a lot of letters. I don't know if it's in the e-bundle or no, but there is a lot of letters for the engineer evaluation and the invitation to attend the site for the site valuation to MESC and MESC reply as well.
Okay, well, I'm sure Mr. Dillon Malone can take you to those in his re-examination. I suggest to you that there was no formal valuation conducted by NAGA, and it certainly wasn't sent to the parties. Would you agree with that?
No, I don't agree with that.
Now, as I understand it, the valuation or the assessment of work done is the 8th of December 2019 evaluation. Is that what you're referring to?
Yes, exactly.
Now, the valuation that I have is still in an Excel format. Are you aware as to whether it was ever finalized into a PDF format or any other format other than Excel?
I don't know if we have the PDF format or no, but this file, the Excel file, I have personally received it by email, and he shared it, the engineer, they have shared it with all parties by email. And the same already mentioned in later on letter. The percentage with the value of work have been recorded and mentioned in a letter.
Now, in relation to this, I mean, if it's a formal assessment, would you agree that it's relatively unusual that it was still in an Excel format? Would you agree with that?
Why? It should be in Excel format to check the link, the relations. Otherwise, if there is any arithmetic error, how you will understand it?
Shouldn't it have been fully formalized and finalized before it was
after all parties review and confirm, then it will be formalized.
But in this case,
But
as far as you're aware,
from if we are talking about the same from the first payment application of MESC, the same process, Excel format shared with all parties for the evaluation, then shared formally by a payment certificate. So it is the same process from IPA number 1 till the final valuation.
Okay, well, we'll come to this document. It's at bundle K, and it's document 81. So if you need a page reference, it's 3736. To access it, because it's an Excel, it needs to be downloaded. So you need to click on the hyperlink at the top.
Hyperlink at the top. Download via the link above. Oh, I see. Yeah, I'm there.
Thank you, Anna. Do you have that, Mr. Resk?
Yes, I have it.
Yeah.
So we have this Excel document. Mr. Resk, would you agree that there was no evidence provided to support this valuation? So there was no, all that's been provided, and it's MESC's case that this was only provided during these proceedings, but even if it was provided earlier, would you agree that there was no evidence provided to support the figures in this document?
Which evidence need to be provided to support this evaluation?
Well,
the evidence would be if MESC attended the evaluation at the project, it will be clear evident for point by point. But since they refuse the evaluation based on the current status, however, there is a status report made by the engineer for the site condition on 4th of November, which before the termination by 2 days, which support, or it can be substantiation to this evaluation as well.
But in relation to this valuation itself, no pictures or inspection requests or anything else.
No, it is not required for the evaluation. It is not required to attach any pictures. This is the engineer role.
But under the contract, aren't you supposed to provide supporting particulars?
No.
If I could just take you back to page 20, so it's page 88, which is in bundle B, document 3, page 88.
Page 88. Wait a moment. How do I get shot of this?
Your Honor, it might be useful to keep up the Excel or keep it on your computer, because I'll be coming back to it.
Yes. But you want me to go to something else in the meantime?
Yes, just briefly, Your Honor. It's at page 88, so
Okay.
bundle B, document 3.
Okay, wait a sec. I can't see how I miniaturize or get off my screen the document that sets out the figures, the Excel.
Could it not be minimized?
Well, it doesn't give me any
Unless you press escape.
escape. Escape. Well, look, go to the next document, and I'll listen carefully. There's a transcript. You carry on. Don't be held up like this.
Thank you, Your Honour. Well, on this page, do you have it, Mr. Rezek? Yes, you can see at 3.5, it states there, engineer shall give notice to both parties of each agreement or determination with supporting particulars. So you accept that actually there is a requirement to provide supporting particulars.
The Excel file is the particulars required.
Okay, well, I suggest to you that there is a requirement to provide the supporting evidence behind the evaluation.
How he reaches evaluation, he's providing the particular, which is the Excel file. But to provide picture, there is no anything in the contract stipulated that the engineer should provide pictures as a proof. And the same applies for all determinations by the engineer. It is not required any pictures at all. Only he has to provide particular how he reach this figure. The same already provided in the Excel file.
Okay, well, let's go to this valuation now. So let's go on to the Excel file. Now we can see if we go, Your Honour, do you have that up?
Yeah, I have it.
Yes, I've got it. Yep.
Yes, if we just go to Appendix A.
Okay.
You can see it, Appendix A.
Yes, Appendix A, I've got that.
Tab. You can see in the far right column it says 85.15% complete, correct?
Yes, correct.
Could I confirm, is this both financial and physical completion?
Exactly.
Are you aware of any errors in this document?
No, I'm not aware about any errors, but still, this is not the final. You have to add the below adjustment as well, the variations, the BC adjustment, the BS adjustment, the material on site to reach the final evaluation.
Okay, well, I just want to take
85.15. This is for the above builds, but you have to consider the below as well.
Okay, well, Mr. Rezek, I just want to take you to a couple of parts of this document. If you could go to tab 01, so if you go to along the very bottom where all the tabs are, it's if you click the 3 dots and a couple of times you'll get to tab 1.
Okay.
Do you have that, Your Honour?
Yeah, I have it.
Yes, I've got it. Yeah.
Okay, great. So we're on tab 1. Now we can see here, oh, sorry, 1 second. Okay, we can see here, I want to look at, if you can scroll down until you can see line 106 at the bottom. So you can see at line 106, there's a figure that says 88%, and then there's a figure that says -9%, and then a figure that says 79%.
Yes, correct.
Now, can you see above that in line 75, 76, and 77?
Yeah.
Okay. In column G, in line 75 and 76, it says 10 and then 69. Now that would add up to 79.
Correct.
But the figure that we have at the bottom is 88%. Then in current, there's 0%, 0%, 0%, and then in the bottom it says -9. So would you agree these two columns, there appears to be some sort of error? Would you agree with that?
Yeah, I agree with that.
And the error, well, there's some sort of error, but there's, in relation to the 88% figure, it's correct that there is a revision down of 9%, isn't there? Would you agree with that? There's a revision down of 9%.
Well, that's what it seems to say on that bottom line.
It seems to be like that. It seems to be like that.
Okay, I've got a very similar set of questions, so I'm going to try and be quick with them. But if you could go down to line 161, so same tab, line 161. And we can see here it says 95% in previous, -10, and then 85. And again, we can see there's a similar issue. It says 25 and 60. I think actually, so lines 120 to 122 and 135 to 137 are applicable in relation to this. But they're the same, it's the same figures. So 25 and 60 obviously don't add up to 95. And 0%.
Yeah, it seems there is an error, but however, the 85 it's matched with the top values, 25 plus 60, which match with the 85.
Yes, correct. So
at the end, the final value, which is a sum of the top 135, 136, which is correct.
So you are suggesting that you think, or well, based on this document, you think that the figures here in relation to the previous are accurate, and actually the effect of these errors is nothing or nil.
Yeah, I believe that.
Okay. Well, I just want to take you to a different document. So just to clarify, the previous column is setting out what was previously certified. Okay, so let's just go to that payment certificate. This is in, if you go to bundle Q, and the document number is 9948.
9948.
So it's bundle Q, and it's document 9.
Yes, I'm there.
Now, this is the previous, this was the payment certificate for,
okay.
I think it was issued in September 2019. So this was the previous payment certificate. I appreciate it's quite small figures, so you might need to expand it a little bit. But you can see there, under item D on the left, construction plant and tool, and you can see in the current column, the cumulative column, it says 10%, 78%, 88%. And then actually...
This is true as well. This is true as well.
So if we go down to the next column, so the next page, and this was the other example that I took you to, and you can see there's 25 and 70, and you can see at the bottom there, 95%.
Yeah, I agree with that.
So actually, when we were looking at the Excel sheet, and when you suggested that, well, it appears that they were originally 78% or 85% respectively, actually that's not accurate. And
no, it's accurate as well.
Well, it's not accurate, is it? Because if, if the previous payment certificate clarifies in the PDF that it's 88%,
we are talking particularly in the first bill, the mobilization bill. And when I was an engineer, the temporary works or the mobilization activities, there is 3 items. There is mobilization, which is the initial running cost, which is related to the time duration, and the demobilization, which is coming at the project handing over. If the engineer, he over certify for one payment, and then at the determination, he realized that he already over certified for the running cost, which need to be adjusted in the final evaluation, he has the right to do that. Even myself, if I over certify one item for the contractor, And later on, I discovered that he made that there is a defect in the item. I have the right to adjust the value as well. This is the engineer role.
Well,
And when we are talking about the temporary works, how can I certify if I'm engineer? How can I certify 90% and still we are at the determination time 85%? I should keep a value for the remaining duration.
Well, that's not the answer to the original question that I asked, which was that what we just discussed in relation to the previous column, that's incorrect in relation to the 8th of December valuation, isn't it?
It's correct as well. It's match. The previous column is match. If you check the Excel file, the previous column 88, it's already 88. There is adjustment by 7% by 9% of the engineer to reach 79. And
Well,
already the equation is there as well.
I suggest to you that there's no genuine reason as to why these sums, why a previously certified sum would be reduced. Would you agree with that?
No, there is a valid reason for sure.
But we don't have any particulars or any explanation for why this has been revised down, do we?
If MESC attended the evaluation, they could understand that already 15% of the work is remaining, and they cannot get the construction planned for 100%.
I suggest to you that these sums have been deliberately reduced, or erroneously affected. Would you agree with that?
I don't agree with that.
Well, let's go through some of the other contemporaneous evidence which goes towards the valuation. If we could go to, so that it's in the case lines at page 4354.
4354.
Yeah.
So it's L12.
Yes.
This is a transmittal document. If you go to the, this is a transmittal document, and you can see there in the manuscript. Now, what I'm interested in here is, you can see in the second paragraph, it says, as per this program, the completion for most of the works have to be written within September, and some small amounts of the works up to the middle of October. That means if we consider that 87% is the completed percentage up to date. So would you agree that this document, which is a document written by the engineer, is evident that the works were 87% complete at this stage?
We don't agree with the percentage at all. The engineer, he already made in all the minutes of meeting that the percentage provided or only provided by MESC, which need to be re-evaluated. It's already recorded in the minutes, by the way, by the progress meeting, that it's only provided by the MESC in the dashboard. To verify this percentage, we need to get the XCR file, which never provided by the contractor. However, if we compare the payments certified at this time, it will never match with this figure. The same already recorded by the engineer in the progress meetings.
Well, this isn't a program. This is manuscript by the engineer, and they say if we consider that 87% is the completed percentage today, correct?
He mentioned as per this program, the completion as per this program, as per the provided program. He's telling facts about the provided program. He's not telling this is his evaluation. Evaluation is different than telling a fact about the provided program.
Okay, well, let's move on into next document. So if we go to page 4357. We can see here at item 2.2, in comparison with the new proposed program for the remaining works, the actual completion percentage is 91.1%. So again, I mean, these are agreed minutes, aren't they? So this is evidence that the completion percentage was above 90% at this stage, isn't it?
He mentioned clearly as per the new proposed program. The new proposed program is not the baseline. It's mentioned in the submittal, which we have referred before. This the reference for proposal, program for the remaining work. We cannot evaluate the percentage of work based on this program. It's already mentioned by the engineer that this program only for monitoring purpose for the remaining works. And the same here, he's telling fact about the provided program. If the resources already adjusted by the contractor to increase the percentage of work done, the engineer has no control over that. And the same engineer, he mentioned here at the end, MESC has to justify. It means the soft copy, the evidence itself, not provided to engineer to clarify the percentage.
Okay, well, finally, in relation to this, and I know your point, and we'll come back to that in a moment, but finally, just in relation to the evidence on these points, we go to page 4363 and item 2.2a. So again, and I appreciate what your response is likely to be. It says here that the actual completion percentage is 93.2%, correct? Well, if, as you're suggesting is the case, that in fact the completion percentage was less than 85% at this stage, exactly. that's quite a significant difference, isn't it? That's an 8% difference over an entire project. It's a big difference, isn't it?
There is a big difference for sure. The provided program, which they have made later on in September, is totally different comparing with the baseline. Totally different with the provided evaluation earlier by the engineer. So if we are taking the percentage from the provided information by the contractor, how can we judge the percentage if we don't have the soft copy or the XCR file for the engineer to evaluate? It's only dashboard provided by the contractor showing the same, which at the end, the actual or the percentage need to be clarified by the contractor.
Given that if there was such a big percentage difference as you suggest there was, why isn't this noted within any of these minutes? Surely it should say, well, I know you say 93, but actually we think it's 84, or it's nowhere near 93. I mean, it's just such a huge difference. Why is that not noted anywhere?
What the engineer have mentioned here, it's a note. He's telling in comparison between the new proposed program for the remaining work and the actual completion percentage for this week, it's 93.2. So he's telling what he's getting from the provided program of the engineer. He's not telling his evaluation. He's not telling his the fact of the progress at site.
Wouldn't this be pretty important information? Because as he's saying here, he's saying, well, it's going to need to be on 3.5% a week to be in line with what you're going to be completing at. And actually you're saying 1.2%. Now, if in fact the real level of completion of the works was around 84% complete, not 93, in fact, the works would be taking a considerably longer period of time to complete, wouldn't they? So isn't that quite an important point for the engineer to have pinned down on?
No, it's totally different approach. If the engineer is doing his evaluation for the progress outside, totally different than what he's noting for the provided document. It's totally different approach.
This goes towards when the project's going to be completed by. So wouldn't the engineer want to be saying, okay, no, you're saying there's only 7% left, but I know there's 15% left. That's going to take at least this many months left. Wouldn't the engineer want to be saying something like that?
Yeah, for sure. He already sent the notice for that as well.
Well, he doesn't record it in any of these project meetings, does he?
Maybe not in the meetings. It's already sent later on the notice of delays.
I suggest to you that.
And if we look on the same minutes, if we check the other activities, which shows the progress of each and single activity, which is the construction. All bending top hinge windows material have been delivered except 3 pieces. Rectification, all these remaining works, we will understand very well that plenty of work are remaining. If we are in 93%, we have to go for the authority approval. We have to go for the taking over of the project to the local authorities, which this is not the case at site. We can go with local authority. We can go with local authority handing over if we are in 90%. So if the contractor reached 93, why we didn't start the local authority handing over?
Why isn't any of this recorded in the minutes? Surely this would be an important point for the engineer to have made within the minutes if there was such a substantial.
So it's already mentioned here in the below sections. It shows all the status of each activity. If we read all these points, we understand even we are less than 85%.
Okay, well, I think we've got your evidence on that. In relation to the cost of completion, so slightly separate, but it's related to valuation. Now, my understanding is, and I may, well, I didn't see it referenced within the reports, quantum reports, but is it right that the engineer didn't undertake a valuation of the costs to complete?
Cost to complete already issued by the engineer as well.
Okay,
After the termination.
Okay, well, we can review the documents on that. Now, within your witness statement, moving on to a separate point, you reference workers' strikes and subcontractor payments and other items along those lines, in an effort, I would suggest, to paint MESC in a bad light. But isn't it right that all of these issues are common day occurrences on construction sites? It's very common that subcontractors are paid by the employer. Would you agree with that?
I don't agree with that. At the same time I'm dealing with MESC, I was having 5 running projects. No one of them are having strikes. No one of them are having non-payment to the subcontractor.
Well, I suggest to you that in reality, these are everyday occurrences on construction sites as construction.
Maybe currently after the pandemic, but at the same time, the time of the project, this is not the case at all. Labor strikes, non-payment of the subcontractor, this was not the common scenario at this time.
Would you agree that if MESC was not being paid the full amount within its payment certificates, this might be a reason why it was unable to pay its subcontractors?
If
MESC was not being paid the full amount within its payment certificates?
Yeah, for sure. If they are not getting full payment, any contractor will not get full payment. He will not pay the subcontractor.
Okay, I'm going to move on. In relation to the DEWA inspector, so within your witness statement, it's at paragraph 52. So that's page 250.
Okay.
You mentioned here, I think it's a paragraph 52, MESC prevented a DEWA inspector from accessing the site. But this was on the 6th of November, wasn't it?
Yes.
So the same day that MESC got terminated.
Exactly.
How could MESC have facilitated an inspection if they'd just been terminated and been ordered to leave the site?
An inspection already scheduled from the previous week.
But they'd just been terminated and required to leave the site.
An inspection already, you have to apply for an inspection, then you will get scheduled for an inspection. So an inspection already pre-planned the previous week. It's already booked from end of October.
Whether it's pre-booked or not, MESC has just been suspended or terminated from the site and required to leave immediately.
No,
I think it's a bit unreasonable to complain about them not letting on a DEWA inspector if they've got to leave the site.
Termination already made COB 6th of November. The inspection, he came to site 9 o'clock.
Well, I suggest to you that
I was present in this case. I was there at the same time for the inspection. They didn't allow the inspector to enter the site.
Well, I suggest to you that on the day that they were being terminated, it's a bit unreasonable to expect them to facilitate an inspection when they've been required to leave the site.
They had to facilitate the inspection because the termination happened end of the day. At this time, we didn't send any notice to MESC for termination.
Okay. Now I'll take you to paragraph 132. It's on page 21 of your witness statement. You state here that the actual cost of Panther of remedying the defective work and the cost of completion was at 9.4 million. And now it's right that there's no schedule of defects setting out exactly what defects were there and the costs of rectifying those defects. Are you aware of any information which sets out what those costs are?
We have 84 open NCR issued to the contractor at the time of termination, and they didn't close it. This is a record of all the defects. So all these NCRs have been closed by us.
But there's no schedule of information detailing the costs of remedying those defects or the estimated costs, is there?
It's already included in each subcontractor and our contractor's scope. We include the rectification of each and single open NCR in their scope.
Are you aware of the experts, of your own expert, Mr. Allen's analysis of this 9.4 million figure?
Yeah, I'm aware.
Are you aware that he's cut it down by almost half?
Yes, I agree.
So actually all of these costs weren't incurred in relation to the costs.
It were incurred. There is some scope. This is the total value we have spent to complete the project. However, some items like the kitchen, it was descoped and paid by us. So it is not recording against MESC. This is why there is a difference between what we have spent and what is coming or fall in MESC cost to complete. There is a big difference. But 9.4 million, this is the actual cost we have spent to complete the project.
Okay, moving on. Related point in relation to, if you go to paragraph 134. Now you state here, because of MESC's breach, including the unavoidable diversion of staff away from business activities. So this is diversion of Panther staff. But isn't it right that Panther were actually incorporated for this project in itself, and they only had this project ongoing at the time?
Yeah, exactly. Panther were having only this project at this time. But as our staff, we have deployed fully to complete the project. This is the diversion.
But if Panther only had this project ongoing, surely they were only involved in this project, so I don't see how they can be diverted.
Panther are only involved in this project, but as our team who was following up the project, we were not following only Panther project. And that's why the diversion came. We were, after the termination, 100% allocated for this project to complete it.
So it's after termination that you alleged that the staff were diverted?
Yes.
Well, I think we're going to explore that a little bit more.
And the same before termination. If the completion made on time, we could handle another project. However, this project took more than the required from our time.
Okay, well, we'll explore that issue a little bit more with the other witnesses. Just briefly, finally, in relation to quantum, paragraph 135, you say that, and again, we'll explore this with Mr. Krajiev shortly, but that Panther would have had the opportunity to sell the units earlier. And you say that I confirm for my part that the sale of the units was the original and always remained the business plan. Are you aware of any documentary evidence which substantiates that comment?
What do you mean, any document to substantiate?
So you say there that it was always the original business plan.
Yes, always our business plan, our own business plan, always to sell the units for all our projects, not only for this project.
Okay, well, my question to you is, are you aware of any documentary evidence which supports that statement? Okay.
I know only what we have for our company plan.
Okay. So you're not aware of
this question, Abul Qasim, he can provide a document for that, I think.
Yes, I'll be discussing it with Mr. Abul Qasim. Okay, moving on in relation to the delay. So this is at paragraph 143 of your witness statement.
Okay.
Just briefly, sorry. Well, I'll come to the delay in a moment, but I don't need to go back to the witness statement. You mentioned earlier, you said a part of our business plan in relation to the off-plan sales. What do you mean by our business plan? Do you mean Panther's business plan?
Panther business plan. Panther business plan.
Okay, delay event 1. And now you say here, paragraph 143A, the delay was due to the late submission of the insurance application and the trackees accreditation card, which is a mandatory precondition for the release of the IFC. But actually, well, sorry, firstly, where is this mandatory precondition? Is it in the contract?
It's not in the contract, and even the IFC not mentioned in the contract as well. Releasing the IFC not shown in the contract as well. So if we apply the same condition, it is not contractually to release the IFC to the contractor. He already received the contract drawings. He already received the authority drawing to proceed with the work. And this is the normal practice in the market. If I'm receiving the authority drawing, I should proceed with the work.
What I want to concentrate on your evidence here, though, because you say it's a mandatory precondition that there is an insurance application and a trackees accreditation card. Where did that precondition arise?
It was recorded in the minutes that that MESC should provide this document in order to release the IFC. It was a precondition raised to MESC to comply with, and they failed to do.
But if it's not in the contract, then why do they have to provide it?
It's mandatory to provide. Insurance already there in the contract. It's already showed in the appendix to tender. Insurance already there. And they have to comply with. Tarakhis accreditation cards, they cannot get the NOCs from the local authorities without these cards. So it's preconditioned.
All I'm hearing, Mr. Rezik, is that you're just saying it's a precondition, but there's no documentary contractual provision that says these need to be provided.
For the insurance, it's contractually required.
Would you agree that in the baseline program, it confirms that the issuance of the IFC was to be on the 11th of July?
I agree with that.
And also, you referenced the insurance application and trackees, but that wasn't the reason given by the engineer for the refusal of this delay in EOT1. In fact, they just said in EOT1 that the contract documents were not signed. Are you aware of that?
Yeah, at this time, the contract document signed later on.
Okay, well.
And the contractor, he proceeded based on the LOI.
That's a different reason to the one you've given here. Contract documents not being signed is different to what you've said here. Would you agree with that?
No, I'm not talking about the not signing the contract documents. I'm talking about the records of the meetings which we had with, or which the engineer had with MESC at this time. it was minuted from the first minutes of meeting. They have to comply with this requirement to release the IFC.
And actually, I mean, the letter of intent was signed on the 11th of July, wasn't it?
Yes.
Or actually, the contract document was signed in July.
No.
You're aware that Mr. Allen, Panther's delay expert, has confirmed that there should be an EOT for this event. Do you have any comment on that?
No, I have no comment. He has to address that.
Okay, moving back to your witness statement, you say that in relation to the Etisalat do cable, you say this did not cause the delay, but
Yes.
have you executed any form of delay analysis?
I didn't form any. I'm not a planner to do any time impact analysis. However, when I look into the reports, it clearly shows that the progress on site at this time, it was ahead than the baseline. So how come there is a delay? There is impact on the progress. Excavation plan to be started on 4th of October. In 4th of October report, it shows that most of the excavation already done. So how there is any impact by DO? However, there is no notice from DO or Etisalat for the work stoppage. There is no notice from the engineer to stop the work.
Okay, well, we'll explore that more with Mr. Allen, but I suggest to you that as you haven't executed any form of delay analysis, you are unable to confirm whether it caused delay or not. Would you agree with that?
No, I'm given from the supported document which I have seen and the current progress at site.
Okay, moving on to the delay event 3, you say here in relation to the post-tensioning drawings for podium slab. Now, you say here that the completion of these activities, so specifically the submission of the detailed drawings and the approval of the structural detailed drawings, were on time. Is that correct?
Yes, correct.
Okay. Well, let's just go to when these were planned to be submitted. If you go to bundle M, and it's page 5245. Apologies, these are, you might need to expand this out a little bit because they're the figures in it are relatively small. So 5245, and we can see here to be approved on the, so this is submittal of structural designings at podium. So about halfway down the page, ESD SST 020, structural designs, shop drawing at podium. And you can see here, late finish, 20th of December. Do you agree with that?
Submittal of?
So submittal of structural details, shop drawing at podium.
Okay. Okay.
And it says here 20th of December 2017.
Okay. There is 24 days delay float.
Yes, so that's the late.
So the late finish.
Yes, so the late finish is the 20th of December, correct?
Correct.
Okay, so and then if you go to so in relation to the approvals, and these are at page 5249. And you can see here it's near the bottom, about 6 lines up from the bottom. It says here, approval of structural details, shop drawing at podium. And you can see their late finish, 10th of January, 2018,
Okay.
correct?
Correct.
Okay, could I just take you to, it's at, I'll get the page references, bundle M, document 35, and the page reference is 5467. And this is a letter from MESC to NAGA. And you can see here that it says on paragraph 2, NAGA did not submit the design for trackies until the 15th of January 2018, correct?
Yeah, correct.
So if they'd only submitted it on the 15th of January, that must be later than when the submittal was supposed to take place, and indeed later than when it was supposed to be approved by trackies. Is that correct?
Not correct.
Why not?
Where is تراخيص approval in the baseline? In the baseline, it shows engineer's approval. Where is تراخيص approval in the baseline?
Well, okay, well, let's just focus on the submission. It was supposed to be submitted on the 20th of December, correct?
Okay, correct.
And it was actually only submitted to trackies on the 15th of January.
First of all, they have submitted 5 days delay, correct? As per the first item, 25th of December. What was the late submission date? 10th of December. They have submitted date.
The submittal date was the 20th of December. The approval date was the 10th.
So they have submitted on 25th.
No, they submitted it on the 15th.
No, here, as per the letter, you confirming our submittal and approval for post-tension drawing on 25th of December. This item number 1 in the same letter.
Okay, well, even if we just concentrate on the approval, it was to be approved by the 10th of January.
If the submittal,
Don't cross again. Don't cross.
If the submittal came late, for sure, the approval will be later than this date.
Well, do you accept, though, regardless of whether submittal was late or not, do you accept that your witness evidence on this is incorrect?
No, it's correct.
Well, we've just gone through when the dates were supposed to be, and we can see from here that it can't have been approved before the 10th of January, can it? Because it was only submitted to trackies on that date.
My statement is correct. Here we mentioned clearly 14 days along with 21 days float, which we have received as a submittal on 25th. We received the approval from Tarakhis on 20. So we didn't use 25 days. Here we have 14 days, 21 days float, so which is within the time allocated in the program. So how my statement is not correct?
Okay, well, we can deal with that in closing submissions, but I do suggest that your witness statement is incorrect in relation to those points. Going to delay event 5. So in your witness statement, which is that paragraph 143. So delay event 4, even 143D. You state that MESC officially submitted the typical drawings on the 8th of March 2018 and received approval on the 21st, and then received trackies approval on the 27th. If we just go to M45, which is page 5555. We can see that they were actually originally submitted on the 26th of February 2018, correct?
Correct.
Okay, thank you. Moving on to delay event 8, so back to your witness statement. So delay event 6 in your witness statement. I think there's the delay events have different numbers, confusingly. But delay event 6, and you say
which delay event?
Delay event 6 within your witness statement.
Okay.
And it's in relation to the finalization of the 12th floor structural designs.
Okay.
Now you state that the presumed dates are wrong. The slab was cast after the 7th, and the formwork was on the on that day. And you say, well, it's right though in relation to this delay event that the design was significantly delayed until August 2018. Is that correct?
Why delayed? What is the reason of delay? First of all, the design by the contractor, by MESC, when they did the submission. the design is not a part of the employer or the engineer scope. For the BT design, it is the contractor responsibility. So when they did the submission?
Okay, well, I think we'll explore that issue with Mr. Allen tomorrow. But it is correct that the approval of the design was delayed until August 2018. That's correct, isn't it?
Because the submission came later in August as well. They failed to do the submission on time.
But you haven't undertaken a delay analysis, have you?
I didn't do any. I'm not an expert to make any delay analysis.
Okay, well, we'll leave that issue for the experts tomorrow. Moving on to delay event 8. Now, you discussed the finalization of architectural and structural layouts. To clarify, it's correct that these are two different areas of work, aren't they? There's structural, which is superstructure works, and architectural, that's block work, isn't it?
Correct, correct.
And your comment here only goes towards the block work, doesn't it?
Yes, correct.
We'll explore those issues in greater detail tomorrow. Finally, in relation to delay event 12, now you suggest it was MESC who failed to provide the correct structural calculations. Sorry, yeah, your delay event 12 even, sorry. And if we go to, I just want to take you to bundle MD, and it's page 5220. So this is a chronology compiled by the defendant's delay experts. And we can see what I want to focus on is paragraph 47 onwards. Now we can see in particular, we can see in particular paragraph 49 that even at this stage, the claimant was still not clear on what design they wanted, and they were requesting for several different mock-ups, weren't they?
Okay.
So would you agree that even by June 2019, the claimant had not finalized what design it wanted to progress with?
No, also the design of the balustrade falls in the aluminium subcontractor scope. Here for the aluminium balustrade, there is one point. The aluminium subcontractor, he already started making the submittals on 19th February 2019, here as recorded in the statements. Why he took like 1 year to start preparing the design and doing the mock-ups? Why he didn't start from May when he appointed?
Well,
one year gap from May 2018 till April 2019, no progress in this item.
Well, the question is, Mr. Rezek, isn't it right that even by June 2019, the claimant had not finalized what type of design it wanted, as it was still requesting for different mock-ups?
We were not looking for different design. We asked for mock-ups, which is a common practice in the construction. We should ask for mock-up, then we give the approval. And this mock-up had to be done 1 year before.
But it's correct that even at this stage, the claimant had not confirmed which of these mock-ups and what final design it wanted. Would you agree with that?
No, I don't agree with that. Once the mock-up done, the calculation and the calculation finished, the approval already granted to the contractor.
Okay, I'm going to move on. Briefly, in relation to this contract, and I know that my learned friend briefly mentioned in his opening about Panther being an experienced developer, but Panther were newly incorporated, weren't they?
Sorry?
Panther was a newly incorporated company for this project, wasn't it?
I don't know. I have no information about that. This you can ask Abul Qasim about it.
Well, if they were a newly incorporated company, would you agree that they would be inexperienced in relation to the development of properties?
Well, that would depend on those involved in the establishment of Panther, their experience in real estate development. They may have come really as chaste virgins to this sector, or they may have had very considerable experience. I don't know.
I understand, Your Honour. Thank you. I'll move on. We'll go back to your witness statement and want to discuss termination now. Go to paragraph 85, which is on page 254. And he states here that under clause 15.2b, Panther was entitled to terminate with 14 days notice if MESC abandoned the works for 10 consecutive days. To be clear, it's Panther who issued the termination notice, not Naga, isn't it?
No, termination issued by Panther.
But you're the one that's giving evidence on behalf of Panther in relation to the issuance of this notice,
Yes.
correct?
Yes.
Okay. Well, you say here that Panther's entitled to terminate with 14 days notice if MESC could abandon for 10 days. And before I come to the termination ground, you also reference this 14-day requirement in your second paragraph, paragraph 86. You say under subclause 15.2 CI, entitled to terminate with 14 days without reasonable excuse, failed to proceed, correct?
Yes.
Okay, well, let's go to the termination notice. It's at page 902. So bundle D, document 2, page 902. Now, firstly, would you agree that this is a notice of immediate termination? It's not a termination with 14 days notice.
Its notice was immediate termination.
And secondly, I just wanted to, if you go down to page 903, or 90, if you can scan over both pages, 902 to 3, you state here, strategy of exploiting your own breaches to pressurize Panther, further demonstrated by the position that you would only recommence works, which you abandoned on the 3rd of November 2019. So it's right that Panther are alleging the abandonment happened on the 3rd of November, correct?
Correct. Correct.
But Panther terminated on the 6th of November. And now,
Correct.
So even if the works had been abandoned, would you agree that that's only 3 days, not 10 consecutive days?
It's 4 days. 3rd, 4th, 5th, 6th. 4 days.
Okay, well, even if we say it's 4 days, that's not 10 consecutive days, is it?
Yes, it's not 10. I already mentioned it's not 10.
Okay. Now, I'll come back to this document in a minute, but if we can just go back to your witness statement briefly at paragraph 86, and that's on page 254. Yeah, 254. Sorry, paragraph 88 even on page 255. See here at paragraph 15.2k, Panther entitled to terminate immediately if they're in breach of an obligation under the contract and the breach is not remedied. Now, in relation to this, it's right that this is a notice to activate clause 15.2k. There has to be a notice by Panther, doesn't there?
Not necessarily to be by Panther. Already many notices by the engineer sent person to clause 15.2k for MESC to take action within 21 days.
Okay, well, let's just go to 15.2k. This is at bundle B4 226.
4226.
Sorry, 4225. I think actually it goes over both of them.
No. Which page?
Page 225 to 226.
225.
So, yeah,
Okay.
225, and then at the very bottom of it. Now, I'm not going to question you about the interpretation of the contract, and it can be subject to legal submissions later. But just to clarify, it says here, if the breach is not remedied to the employer's satisfaction within 21 days of the employer's notification to do so. So that says employer, not engineer, doesn't it?
No, the engineer is acting on behalf of the employer. This also mentioned here in the contract.
Okay, well, we can subject that to legal submissions later. And we'll just go back to the termination notice briefly once again. So page 902. It's right that within this notice, there's no mention anywhere of clause 15.2 CI or 15.2K, is there?
Yes.
Yes, you agree there's no reference to them?
Yes, there is no reference for them here in the notice of termination.
So Panther didn't terminate pursuant to these grounds within this notice, did they?
It was valid reasons, however, it is not mentioned in the termination notice.
So if we go to your witness statement at paragraph 92, when you say here, on a true construction of the contract, MESC was obliged upon termination of the contract pursuant to subclause, etc., etc. It's incorrect that in relation to at least 15.2 CI, 15.2 G, and 15.2 K, that actually the contract wasn't terminated pursuant to those grounds. Would you agree with that?
The notice of termination only mentioned to 15.2 H and another clause, but here these all points 15.2b, CI, G, H, K, it was a fact at this time. These all are valid reason for the termination, despite it's mentioned in the notice of termination or no.
Okay, I'm going to move on. Now I'm just thinking about the period following termination. A significant number of claims are due to the costs allegedly incurred over this period. And Panther state that it took them around, what, 5.5 months to complete after the termination, correct?
Correct.
Now, even if the percentage left to complete was only 15%, shouldn't it have taken a considerably lower period of time than 6 months, even if you had to get new contractors on?
Yeah, definitely, I agree with you. If the change in the contractor process moved smoothly, we would finish earlier. However, MESC tried to stop the change by visiting Tarakhis, trying to convince them about stopping the change to the new contractor. They called police many times, site invasion, many incidents happened by MESC during December and November, which stopped any progress at site. Actual progress at site started in 1st of January. First application to Nakhil for NCC, which is the compliance statement, which is a completion, happened the end of February. We are talking about less than 2 months. The first transition period, November and December, these are the main cause of delay, which happened again after termination by MESC. They did all their efforts to not let us start or resume the work.
Do you, and I know you referenced that there's notices, are you aware of any analysis that's been done in relation to this specific period, which demonstrates the exact causes of delay?
Which period?
This period following termination.
No, there is no any analysis for that. But we have a lot of records for that. We have the record of the meeting with Tarakhis. We have the site invasion records. We have the police report. We have a lot of records about that.
Isn't it right that actually a new contractor was appointed within 20 days from termination?
Yes, correct.
And that was with a building permit as well.
Building permit obtained on 28th of November, which we can say 22 days after the termination.
Okay, so it wasn't the entirety of these 2 months period, it was 22 days.
Not 22 days. There is, after the building permit issues, MISC called the police many times to site to stop us. So they tried to not let us open the site at all. We suffer even after 28th of November to resume the work at site. And police reports already available as well.
Okay, I'm going to come on to my file.
They did, by the way, also, they did all their best to not let all the subcontractor resume the work with us. This is why we are talking about 2 months fighting with the other to resume the work.
Okay, I'm going to move on to my final topic now. It's right that the engineer generally certified a considerably smaller amount of the payments than applied for. Do you agree with that?
I don't agree with that. Always, with my experience, I have 19 years experience, 12 years of them as an engineer. Always the contractor overclaim. Always.
Well,
There is a significant difference. There is a significant difference between the IBC, the interim payment application, and the certificate. This is the normal practice.
Well, that wasn't the question that I was asking. The question is, it's correct that the engineer certified a much lower amount than the amount being claimed for. That's correct, isn't it?
Yeah, there is a difference. Yes, exactly.
In relation to the payment application, so I think we can go to a couple of these documents just for assistance. The payment application so this is that page 9499. So that's Q99499. Now, in this this is a payment application from June, and in this application, 2.6 million was claimed for, and only 875,000 was certified. Would you agree with that?
I agree with that.
Are you aware that in relation to this payment application, the employer actually only paid 150,000?
Yes, all payment paid as per the pre-agreement with MISC. We started to pay their subcontractor from November 18. So all the amount, which is 875, fully paid to MISC and their subcontractors.
Well, I suggest to you that that's incorrect. I suggest that
it's correct that we have
724,000 was paid less than certified.
Well, just let the witness finish what he was going to say. Yes, Mr. Rezic, go on.
I was myself recording the release of payment to MISC and their subcontractors. We are getting statement from MISC for each payment to their subcontractor, and the remaining amount we are paying to MISC. So each payment, 100% I'm sure, already released to MISC subcontractor and MISC. There is no single difference between the IBC and the payment received to MISC.
Well, I suggest to you that's inaccurate, and actually by September 2019, over 2.5 million of certified sums had not been paid to MESC, even though it's been certified.
You have to look into the subcontractors' payment as well. You are looking to the payment received directly to MESC. What about their subcontractors?
So you're suggesting that 2.5 million of the 3 million was paid directly to MESC contractors?
Yes.
Okay, well, that item can be reviewed. By September, I think there was 3 million in payment applications which wasn't being certified, and I think 3.5 million unpaid from payment certificates. And MESC also had an EOT claim. Now, by that stage, would you agree that a contractor would be slightly concerned about what the employer's actions might be because they were releasing a much lower amount than either had been applied for or they've been certified?
why he will be over concerned if the contractor is over claiming to take all the money in his pocket and to control the site. Why he will be disappointed if the contractor over claiming, the actual work will be only certified.
In October 2019, Panther liquidated the bond of a sum greater than 5 million. That's correct, isn't it?
Correct.
And that's before the alleged abandonment, isn't it?
It's before, yes.
Also, at termination, Panther held retention in the sum of around 3.3 million. That's correct, isn't it?
Correct, correct.
So, by termination, after the liquidation, Panther's holding 3.3 million in retention, 5 million in bonds, and they've also withheld, I think you might disagree with me on this last point, but they've also withheld a sum of over 3 million from unpaid payment certificates. Is that correct?
I agree with the first 2 points for the retention and the liquidation, but uncertified work, this is not the correct statement.
I suggest to you that, in fact, what happened in this case is very common. Employers terminate when works are very near completion, and they encash bonds, and they hold on to retention because then they hold all the cash and they're in a position of power. Would you agree with that?
No, I don't agree with that. Only with my experience, the employer will terminate the project if he feels that the contractor will not complete the work. And this is the case here. On the meeting of 27th of October, clear statement from MESC management, if we didn't sign the MOU, the project will be open-ended. Even 10 years, they will not hand over to us. So it's a clear evidence they will not complete the work.
Those are all my questions. Thank you very much.
Thank you.
Thank you, Rana.
Yes, Mr. Dillon-Malone. You're still muted. You're still muted. That's no, it's still muted.
How's that?
That's it. Okay.
Okay. Thank you very much, Mr. Mesk. I have just a number of points to bring you back to, and if I could please ask you to turn to Q 11489. And you'll see that the entry for this in the section Q of the bundle is described as the payment records. The complete record of payments by Panther to MESC.
Oh, I'm so sorry to interrupt you.
It's
Yes,
it.
Which did you say?
I'm sorry. Excuse me. Is it? It's 8053. I'm sorry. Excuse me.
That's all right. 8053. Just give me a moment.
What numbers am I getting then?
87. Give me it again. 87.
8053.
53.
Okay, wait a moment. 8053. 8053.
Yes, and I think, Mr. Resk, in relation to the last question, and also in relation to an earlier question, that it would be natural for MESC to have been upset if it was not being paid everything that it was owed under the contract. Can you confirm that all works that were, can you please tell the court if all payments that were certified were paid on time by Panther?
All certified payment paid by Panther. I agree.
And if one looks at that complete record of payments in that very long section of documents, will one find any evidence, do you believe, of any late payment or non-payment?
There is no non-payment, there is no late payment at all.
Now, if I could ask you please to turn to page D1235. This is the note and record of the site invasion that you mentioned in relation to the delays that occurred during September and during October and November 2019.
During November and December, both termination.
Yes. And might I just ask you then to turn, please, to page 233, which is in bundle B. You mentioned in the course of your evidence in relation to the question of insurance.
Yes.
The
it's already
appendices.
here. Yes, it's already here in the appendix to tender. Yes.
Yes. And can you point to the court the relevant provisions in the appendices to tender?
Appendix to tender falls after the contract agreement and the priority of the document. So it has the priority over any contract document after the agreement. Here in second page, page 233, clause 18.2, contractor risk insurance, contractor plant and equipment reinstatement value of the contract. This all requirement for the contractor insurance to provide.
Yes. And then the relevant, could I ask you to look at page 229 to 230? And that's clause 18.1 of the contract and 18.2 underneath
insurance.
it.
Yes.
And then if you could just please just turn to page 130 to 133. There were certain amendments in the special conditions, in the particular conditions.
For the insurance.
Yes.
Yes.
And is it correct to say that you need insurance to get Tracky's approval in order to start work on site?
You need insurance to grant access to site. You cannot take the risk by started any construction activity without insurance.
Thank you. And if I could ask you please to turn to section Q. There's an entire section. I think this is the one that begins on page 11489. 11489 in section Q. I was confused earlier.
That's related to the white card.
These
the accreditation.
Yes, these sequence of, you mentioned in the course of your evidence, in relation to the termination notice, that there were many calls by the engineer.
Yes. Yes.
Were they in the form of delay notices?
Yes, exactly. It's a form of notices.
Yes, and I think this section of the bundle includes the sequence of delay notices from the engineer to MESC. Is that correct?
Correct. Correct.
And if, for example, if I could ask the court to, and you to turn to page Q11570. This is a document dated the 8th of August 2019. And if I could just scroll down, please. And that letter is an example in the course of 2019 of the engineer calling on MESC to complete the program, to complete the works and address the slowdown. Is that correct?
Yes, correct.
I think in relation to one of the tables that you were being shown earlier, and I probably won't ask you to open it again, but you had mentioned that there was an equation that supported what you were saying when you were disagreeing with Mr. Burrell about the adding up of the figures.
Yes.
And you mentioned an equation. Do you want to go back to that equation?
No, it's fine. It's fine.
Can you explain to the court what you meant by the reference to that equation?
There is last payment evaluation made by the engineer for he considered a certain value for the preliminary work in two items exactly in the preliminary work, which the engineer after termination he understands that the remaining work need more amount for these particular item, the plant, small plants and the equipment to complete this work. That's why particularly these two items have been adjusted less. Else, everything, there is no adjustment.
Okay, thank you. And if I could ask you then to turn to page 1124. You mentioned in relation to the basis upon which, I think you were asked by Mr. Burrell about whether the engineer had carried out an evaluation of the cost of works or the cost to completion. And you mentioned that there was a status report. This is a document entitled Naga Construction Management Department Work Status and Progress as dated 4th of November 2019. Is that the document you were referring to?
Yes, this is the document which I was referring for.
Yes. And how does this document assist in relation to the cost of completion?
This document shows it's related to the final evaluation. It shows the status of all non-conformity at site, shows the status of each floor with the pictures in the last section, shows in the second page the approximate third page, the to date completed percentage.
You bring up 1265 for me.
So
1265.
this report shows a clear status of the completed work immediately before termination. Even the photos with date as well. So all photos 4th of November.
Thank you. Yes, and there was a further reference by you to, if I could ask you to look at page 1265, I think that's an easier way of doing it. 1265, please.
Yes.
Yes, there's a reference here to a final contract price.
Yes.
That's the bottom of the page. And was that a determination that was made by the engineer after the contract, after termination?
Exactly. This one of the terminations which issued by the engineer to MESC post termination.
Yes. So I think the suggestion was made by Mr. Burrell that there was not an evaluation carried out and of the corresponding claim of MESC post termination. And if I could ask you to open page 928, please. 928. And this is dated the 10th of June 2019. And it's from the engineer to MESC, identifying a sum of 1,546,000, etc., as money due to MESC. Is that correct?
Correct.
And is that a valuation by the engineer of monies owing to MESC post-termination.
This is payment number 18. It's on June 2019.
Yes. Oh, so that's prior to termination. Excuse me.
Prior to termination, yes.
Okay. My mistake. My mistake. Those are all my questions, Judge. Thank you.
Right. Thank you very much. Mr. Barrow, do you have any questions arising out of the equation that was?
I've just got a couple of questions arising out of that re-examination, Your Honour. Just on a couple of topics. It shouldn't take too long.
Yeah, we'll keep it brief because generally speaking, the stumps are drawn at this point. But
I understand. Yes, Your Honour, I understand.
Well, off you go, and let's see how it transpires.
You gave evidence just then, Mr. Rezek, in relation to the alleged insurance provisions, and you stated that you need insurance to get access to the site, and you can't start without insurance. This is in relation to the IFC. But the IFC drawings, you need the IFC drawings to do the engineering, don't you? So you don't actually need to be on the site. This is to allow you to start doing the drawings for the project. That's correct, isn't it?
They can start the engineering based on the approved drawing, the authority drawing, and the contracted drawing. Why they need the IFC to proceed with the engineering?
That's not the answer to the question, Mr. Rezek. The question is, you can start doing your drawings and engineering without needing to access the site, therefore, without needing the insurance accreditation. Would you agree with that?
Yes.
Okay, thank you. Just in relation briefly to the topic that we've just gone on to, or just before this, in relation to the cost of completion, you were taken to a document dated the 4th of November. That's before termination, isn't it?
Before termination, yes.
So that's not a valuation conducted after termination in accordance.
No, it's evaluation because the site abandonment happened on 3rd of November. So after 3rd of November, no progress at site. 3rd of November, site abandoned by MESC. 6th of November, termination. So 4th, this is the status of the project.
And to clarify, there isn't an evaluation at this stage of the cost of completion, is there? It's a valuation of what the current percentage of works are complete. Would you agree with that?
Yep. Which evaluation?
The evaluation of 4th of November. It's not evaluation of the cost of completion, is it?
No, it is not evaluation for the cost to complete. It's evaluation of the current work completed.
Okay. All right. I think everything else can be addressed in closings, Your Honour.
Yes, thank you very much. Well, Mr. Rezek, thank you for your evidence.
Thank you.
You're released as a witness.
Thank you so much.
Thank you very much for coming along and giving your evidence.
Thank you.
Thank you, Mr. Rezek.
Thank you.
Now, before we move on to the next witness, I've just got a quick legal point to raise with you, and we might just take a short break. These quite a lot of details covered in a cross-examination of this nature, and I think a short break might be appropriate. Now, can I take it that in this area of construction law, the ordinary contractual principle that a party who terminates a contract is not restricted to relying on reasons given at the time of termination, but if there were good reasons for the termination, not identified in any notice, reliance can be placed on those reasons, and they are capable of validating a termination of the contract. Mr. Dillon Malone?
Yes, thank you, Justice Field. Precisely, that is our case. You may have seen in our skeleton argument that we have referenced some case law on that point, and that is our case. Of course, we have the first point in any event that the delay damages were exhausted, long exhausted, and we had an immediate right of termination, and we did so by notice, and that in itself is effective.
Yes, I understand that.
That's our first point. But then, of course, it is our case that, as has been decided by the Superior Courts of England, and I believe represents DIFC law and is referred to in the leading texts on contract law, and including in construction law context, we have specific cases that have been referenced in our skeleton of precisely this, that an argument was made in the case that we refer to, I can't remember the name right now, that that the notice requirements under the contract were exhaustive of the remedy, and it was found that that was not the case. The common law entitlement under the general law of contract as a matter of construction allowed for the employer to terminate the contract on wider grounds of repudiation. And in our skeleton argument, we rely on both the extreme and clear repudiatory acts at the time of termination, plus to the extent that it may be needed, we don't think it would be, that our anticipation that of a continuing and extreme breach, indeed of abandonment.
The 10-year point. Yes. All right. Thank you very much, Mr. Burrell.
Yes, Your Honour. I understand the point. I'm not instructed to concede it in relation to.
Has it? You practice in this area. Is it accepted by the construction bar and in the TCC that the principles which I think were first developed in a case called the Michaelis Angelis, going as far back as Lord Denning, that reliance can be placed on matters which do constitute valid justification for, it used to be called the rescinding of a contract, is permissible, and one is not confined to any reasons that were provided at the time notice was given of termination.
As I say, Your Honour, I'm not instructed to concede the point in relation to the reliance on grounds. Not.
Mr. Burrell, just that is a totally unacceptable response. I'm entitled to ask you, drawing on your experience at the construction bar, whether or not it is accepted within that legal fraternity and accepted by the TCC in London that the Michaelis Angelos approach is applicable, and a employer who gives stated reasons for termination may validly rely on other reasons for the termination of the contract. You don't have instructions to answer that. You've got obligations as counsel to assist the court. Now, what is the position?
I understand, Your Honour. Might I come back to you on this point tomorrow, and I'll give you my confirmed answer, not restricted to relying on instructions. Might I come back to you on this?
Yes, fair enough. Yes. Now, a short, we're doing, I think, fairly well for time, but would you say?
Yes.
If we were to resume at 20 to the hour, so we give ourselves about a 12-minute break, would that disfigure the planned timetable terribly, or could the timetable accommodate that, a break of 12 minutes?
That sounds perfect. I think if we continue at this very satisfactory rate, we may achieve the fact evidence today. I'm not sure how Mr. Burrell
well, let's see how
will get on, but I think we're doing well.
I think so.
Yes, well, that has been commendably crisp and to the point in his cross-examination of the last witness. I note that. Very well, we shall resume at 20 to the hour.
Thank you very much.
Well, are we all present and correct?
I think so, Your Honour.
Thank you. Yes, I believe Mr. Abulkasim is taking his place,
Right.
Mr.
Thank you very
Akprashiev.
much. Thank you.
Excuse me. My apologies, Judge. There's his computer is reloading, is rebooting, and so it seems there's just a slight delay.
Well, give me some idea of how long.
As far as I know, it'll be immediate. It's just a question because it's the same laptop that was being used for Mr.
Okay.
Resk. So I think.
Well, we'll just hang on until.
Thank you very much.
It's done.
Is it connected? I'm sorry. I'm told now we need IT. I'm very sorry about this. Perhaps we take a 5 minutes.
Yes.
Thank you.
Right.
Hello? I think it's connected now. I think it's connected. I don't know if
Yes,
you can.
thank you.
Can
Yes,
you,
we can hear you. Yeah.
Okay.
I don't know if Justice Field can hear me. I think there'll be less. Thanks, Abulkasim. If you could please just remain on screen. Yeah. Thanks. We had a technical issue in your absence. Yeah. No, unfortunately we've had to take a break, but the judge will be
Are we ready now?
Yes, thank you very much, Justice Field, and our
Right.
apologies again.
Right.
We have Mr. Akprasiev.
Yes. Thank you. Mr. Apragiev, have you given evidence in any court proceedings before?
Not in the commercial courts, no, haven't done anything.
Well, just to explain, witnesses give evidence in this court under an oath. The oath can be taken on a religious book, or it can be a secular oath. The court makes no distinction in the worth of the oath as between a religious oath or a secular oath. What sort of oath would you like to take?
I'll go for religious oath.
And what will it be? Will it be a Christian oath, a Muslim oath, or what?
Yes, it will be a Muslim oath.
It'll be a Muslim oath. Do you have a copy of the Quran there?
Yes, it's in front of me.
Right. Would you take it in your right hand, please? And listen carefully to what I'm going to say.
Yes.
I sincerely and solemnly
I sincerely and solely
confirm on the Holy Book of the Quran
on the Holy Book of the Quran
that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Shall be whole truth, truth, and nothing other than truth.
But the truth.
Yes.
Good. Thank you very much indeed.
Come.
Yes.
Thank you very much, Mr. Akprasiev. I think you have in front of you a copy of your first witness statement in these proceedings, and that's a clean copy.
Yes, I do.
Yes. And can I ask you please to turn to the final page of that witness statement and look at the signature?
Yes.
And can you confirm that that is your signature?
I confirm that is my signature.
And can you confirm that this witness statement is your first statement of evidence in this case?
I confirm.
And do you wish to correct anything in that statement?
No.
Do you wish to clarify anything in that statement?
No.
Thank you. And I think you also have in front of you a second witness statement that you swore on the 16th of September 2021.
Yes,
it's a short witness statement. Justice Field, I've just realized that this particular witness statement may not have been uploaded since your direction this morning. But in any event, can I ask you please to look at the second page of that witness statement at your signature?
Yes.
And can I ask you to confirm that that is your signature?
Yes, it is my signature.
And that this is your second statement of evidence in this case?
That's correct.
And do you wish to add do you wish to correct anything in that statement? No. Do you wish to clarify anything?
No.
Okay, thank you very much.
This witness statement must be uploaded because I need to see it.
Yes.
If Mr. Burrell is in a position to cross-examine on it.
Of course.
He's had it only recently, and we shall have to see what course he takes. So can you ask your team forthwith to get this witness statement onto the e-bundle?
Yes, indeed, and I'll give you the reference as soon as it's done, and my colleague is attending to that right away. Just to say that Mr. Burrell and his team have had that statement since it was on the day it was made, the 16th.
Which was when?
The 16th of September.
On the 16th of September.
Yep, just a few days ago.
Right. Yes.
Thank you. Thank you very much. And Mr. Akprasiev, if you could please answer any questions from Mr. Burrell.
Yes, thank you. One moment. Okay. Mr. Prajiev, firstly, I just wanted to clarify what your role is. You state that you're a representative of Panther. Are you an employee of Panther?
No, I'm fully representing Panther. I have both power of attorney, full power of attorney from the general director, and I'm fully authorized by Panther to carry out any activity.
Well, what is your role? What's your position?
I don't hold any official position at the company.
Well, why were you given a power of attorney?
Because I'm an entrepreneur myself, and because I don't hold any managerial position in the company.
But
However,
this must have been done in contemplation of you performing certain acts, taking certain steps. Now, what were they? What are they?
so we have an agreement between me and Panther to carry out all the activities, and as well, which is attested by the local authorities from Dubai courts, the full power of attorney to act on behalf of both AAB and Panther.
I see. And so, on the basis of that power of attorney, you're authorized to give this evidence.
Correct.
On behalf of Panther. Is that it?
Correct. That's right.
Thank you.
Thank you for that clarification. Now, I understand the evidence that you've given, and I'm not challenging your authority to give evidence on behalf of Panther. What I'm curious about is what is your actual involvement with Panther during this project? What's your personal knowledge of it, and why does it arise from that role?
So I was involved at the very beginning of the project when back in 2014 we purchased the land. AAB Holdings purchased the land from Nakhil, the master developer of the community.
I'm still not entirely clear. The answers that you're giving in relation to this are very vague. You've just been saying I was involved in it at the start, and I have a level of involvement with them. I want to drill down. What exactly was your position with as regards Panther? You stated that you're not an employee. What is your involvement? What's your position?
So I was deeply involved in all the business aspects of the company. So I was involved during the very early stage of doing the feasibility study for the project and making we can say, starting the project as the whole, making the plan, coordinating and appointing the engineer and the architect for the project, as well as doing the strategy for the sales, completion and execution of the project.
Okay, well, we'll come on to those items in a bit more detail, and I'm just going to ask one more question on this because I appreciate that you've given some evidence on it already. But you say that you're not an employee of Panther, nor are you in the management section of Panther either. Are you an external consultant employed by, instructed by Panther? I'm still not really clear on exactly what your role is.
No, I'm an entrepreneur. I'm a business owner as well, which is I have a few different businesses. But in current project, in current case, I'm fully representing Panther as for the reasons I said earlier already.
Well, wait a moment. You're paid, are you? Do you receive a regular payment for your services?
No, sir.
All this is done completely free, is it?
Yes. Obviously, we had a business plan, and we had an agreement with AAB, but that's something I was not in the payroll of the company.
But what you did was you were asked by Panther to assist in general, bring your knowledge and experience to bear on
That's
the
correct.
project from start to finish. Is that it?
That's correct.
I see.
You said that there was some sort of business plan agreement. What's that? What are you referring to there? You said we have some sort of business plan agreement with AAB. What are you referring to?
So the plan we had, actually, we were exploring the opportunity to develop the land which is owned by AAB Holdings, and we did a study, and the study showed that it's an amazing opportunity.
No, sorry. So sorry to cut across you there, but the question, that was an answer that you received in response to the judge's question that you don't receive payment for services. It was all done for free. So I thought that what you were referring to here was some sort of agreement or financially related agreement between yourself and Panther or AAB. Is that what you were saying? Is that what your evidence was or not?
I didn't understand your question. Can you repeat?
Is it correct that you have a financial agreement between yourself and Panther or AAB, which would provide you with payment of some description in relation to your services that you provided during this project?
Can you rephrase it, because I really get I'm not understanding it.
I understand. I'll try and make it more straightforward. Is there any agreement at all between yourself and Panther or AAB in which they agree to make payments to you at some stage for the provision of your services?
No, there is no.
I think you clarified earlier. So this is just all something that you're doing for free.
Correct.
Just out of the goodness of your own heart. Okay, well, we'll move on. I want to talk about the project's current status. If we go to paragraph 28 of your witness statement, and this is page 721 of the bundle. You say here, upon commencement of construction, we were entirely focused on our business plan as a sales project. And I think you reference that there was a report delivered at the end of November, a feasibility study in relation to the values of the property. And you said there was a projection of a net profit of 31.2 million and with a sale value of around just under 89 million. That's correct, isn't it?
Yes.
Now, if we just want to go to paragraph 50 of your witness statement. So on page 274.
Yes.
And you state here, the resulting loss of opportunity and loss of unit sales is in the vicinity of 17.25 million. So you're saying that if we sold now, we'd lose 17.25 million. That's correct, isn't it?
That's correct.
And finally, on this subject, if we just go to paragraph 59, so page 277.
Yes.
You say here that the long-term goal is still to sell it. That's accurate, isn't it? So you still want to sell the properties at some point. Is that correct?
Yes.
But that the only reason you're not doing it now is because you're waiting for the market to be to improve. Is that right?
That's right.
And when you say you're looking for the market to improve, what's the base level that you would consider selling at? Is it similar to what was in the feasibility study? So around 88, 89 million. Is that when you want it to get back to before you sell?
It's very difficult to answer this question because we completed the project during the pandemic, and the market was unexpected at that time. So the whole country was closed. Actually, the whole world was closed. There was a lockdown, and it was obviously big uncertainty for us as a business. And what we had no option but to go for a rental of the building, because we couldn't sell at the moment. And you know, as per the laws of UAE, once you lease the units, it is not easy to vacate the flats. And currently, just to update, we are in the process of giving the notices to the tenants that we have a plan to sell in the future. So once the notice is served, 1 year notice to vacate, and we get a chance to start the sales, then obviously it will be clear. But for now, it's not clear what will be the final outcome.
So you're saying it's not clear what you're going to be able to sell them at, when you're going to be able to sell them. Is that what you're saying?
No, at the moment it's very difficult. Yes.
But what would you be hoping to sell them for? What was, you know, you've obviously kept it on the rental market for a certain period of the time. When you release it back onto sales, what's the sort of bar that you're wanting to reach? Is it what I suggested earlier, which is about the 88 million mark? Is it lower?
Well, it will completely depend on the market and the offer we will be receiving. But currently we are not able to sell because we have tenants living in the building, and the building is rented currently.
Okay. All right. Well, let's move on. I want to move back to the off-plan point. Well, not briefly. This will be a point that we're going to explore. Okay. So you suggest within your witness statement that Panther initially wanted to push for an off-plan sales strategy. That's correct, isn't it?
Yes.
Are you familiar with real estate development in the UAE?
Yes, I do. I am.
And are you familiar with the process of coordinating a strategy to sell off-plan units from an ongoing project?
Yes, I'm aware.
Usually, would you agree that if pursuing such a strategy, you would have some sort of sales strategy document detailing how you would market and sell the properties? Would you agree with that?
Correct.
Are you aware of the existence of such a document in this case?
Yes, I'm aware.
So you're saying that there is a document setting out the sales strategy, or the off-plan sales strategy of Panther?
I confirm that, yes.
Is it exhibited? As I understand it, you haven't exhibited any such document to your witness statement, and I'm not aware that there's any document disclosed. Are you aware? Is it within the bundle, to the best of your knowledge?
I don't think so. It's not in the bundle.
Wouldn't this have been an important document to provide in relation to your evidence, because it would support your case that actually an off-plan sales strategy was being pursued? The question is, wouldn't it have been important to have provided this document?
We provided these documents to the experts.
Okay, well, we'll review that. In Dubai, there's lots of developments being put onto the market, isn't there? Lots of new properties frequently entering the market. Would you agree with that?
Yes.
And would you agree that Dubai is a relatively competitive market for selling off-plan properties?
Yes.
And so during this period, would you agree that it's very common for developers to offer to sell their properties on a payment plan?
Well, can you repeat your question?
Would you agree that it's very common for developers to market their off-plan properties or market and sell them by using a payment plan? So not 100% purchase price, a payment plan staggered over a period of time. Would you agree that that's very common?
Yes, it's common, yes.
As far as you're aware, is it right that Panther actually never formulated any strategy to offer payment plans to prospective purchasers in relation to this case?
The sales strategy was established in 2017, and we had great expectations and great plans actually to be able to market and sell, as a lot of other developers have done in the community where our building is. We have certainly other good examples as well, where the developers similar to us have done quite a good sales.
So is the answer to that there was a plan, there was some sort of plan to offer it on a sales, to offer payment plans to purchasers, or not?
Well, definitely during the initial stage, we had different plans for the sales. Yes, we had a plan where we wanted to sell off plan, and when you sell off plan, obviously the market practice is customers, they pay by milestones until the completion of the project.
So your evidence on that is still a little bit unclear. You're saying that you might have had a plan to offer it on offer payment plans, but actually that was never finalized. Is that what you're saying?
No, we had a solid plan and we were planning for it, but that never happened because we had delays in the project. And actually, just to explain what has happened, as per the local regulations, local government requirement, in order to be able to sell off plan, as a developer, there is a certain milestone that needs to be achieved. And with our contractor, with the delays on site, it was very difficult for us to reach this milestone. It was every time it was getting postponed, and we suffered greatly from that.
Okay, well, we'll come to that in a moment. But I wanted to get your evidence clear on this then. So it's your evidence that you did have a solid plan to launch an off-plan sales strategy. And am I right in thinking you're saying that there was a solid plan to offer payment plans to end users? Is that what you're saying?
When you say payment plan, can you define on what exactly you mean payment plan?
Mr. Burrell, the witness has said that when you sell off plan, normally the purchaser pays over time when certain specified milestones have been achieved, which is a sort of payment plan, but it's very closely associated with selling off plan, and it's in respect of certain specified milestones in the completion of the development. That's his evidence.
Yes, Your Honour, I understand his evidence was that that's what the market practice was. My question was whether...
He said that was the plan of Panther to do.
Okay, well, that wasn't clear from what I'd heard, but I'll note the point.
Well, let's just make sure that I'm not jumping to conclusions. Have I got it right? My summary of what I understand your evidence to be. Do you agree?
Yes, I do agree, Your Honour.
Thank you very much.
Okay. Do you have any documentary evidence at all which would support the evidence that you've just given, that there was a plan to release these units with some sort of milestone payment plan?
Well, we had the marketing brochures done. We had the communications with most of the brokers in Dubai. We had a solid plan. I mean, we approached RERA. We have the communications with RERA, which is the Real Estate Regulatory Authority, who registers the project, and then they issue the license to the permits to sell off plan. We have done all that. Yes, we do have them, and we provided most of these documents to the witness as well, to the expert. I'm sorry.
Okay, well, it might be something that I'll come back to in relation to that. But as far as I'm aware, this and Mr. Dylan Malone, you might be able to correct me if I'm wrong in relation to this. But this documentation that Mr. Akpraziev is referencing, so the market brochures and the permits to sell and the approach to RERA, does this form part of the bundle? Do you know, Mr. Dylan Malone?
Not that. No, I think that the material that was relied upon by Savills is referenced in their report.
I might just have a couple of minutes, Your Honour. It won't take long.
Yes, by all means. We'll just mark time.
Thank you, Your Honour. Much appreciated. So I think the relevant report, the relevant paragraph or part of or page of the report of Mr. Paul, which details the information, is at page 370. So page 79 of 83, and that's in C5. We have here information provided by the client, and I think there's 5 items: project inventory details, project rental performance details from May 2020, site affection plan and floor plans, project brochure, and taking over certificates. So that's the information that was provided to Savills by Panther. So just in relation to this then, Mr. Akpraziev, I think you do reference the brochure, and there is a reference to a project brochure here. But apart from that, in relation to the other documentation we've just heard you reference, so the issued permits to sell and others, have you provided any documentary evidence to, or in this case, of that documentation?
Yes, we did.
Okay. Well, for one reason or another, it doesn't form part of the bundle.
You can question the witness, the expert tomorrow on that.
Okay. Well, he doesn't list it within his report of the documentation that he was provided with by Panther. So it looks like from his report it wasn't provided to him, unless he's missed it off. When a project's being developed and there's a decision to go off plan, would you agree, Mr. Akpraziev, that it's a relatively important decision because it has significant financial implications? Is that correct? So would you agree that it's an important decision to decide whether you're going to go off plan when the project's in development? Would you agree?
Yes,
that that's
of course.
important?
Of course.
And so wouldn't you have some form of document which would detail exactly what the strategy is?
We hired one of the big four auditor companies, the most reputable firms, who has done full feasibility study, which showed actually that the project is how feasible it is, and it was, as I told earlier, it was a great opportunity, which, based on these calculations and the plan we have gone for it. We've commenced the project based on this, and the plan was, yes, obviously, to sell off plan, which I already highlighted earlier, and it was, yes, it was very important and.
So to clarify your evidence there, the only documentary evidence that you're aware of, which would set out Panther's strategy in relation to the off plan, is this feasibility study. Is that correct?
Yes, it can.
Okay, that's the only bit of documentation. Okay, we'll just go back to your witness statement, paragraph 50.
Okay.
Now you state here in paragraph 50 that Panther would have had an opportunity to sell these units with a launch date estimated at November 2017. So it is your evidence that it was always Panther's plan to launch in November 17. Is that correct?
Correct.
Now I know we've been through the documentary questions already, but I'm just going to ask you one more in relation to this point. Are you aware of any documentation which was prepared by Panther, either before the start of the works or after, which sets out the month of November being the launch date for the off plan? Any documentation at all?
Well, it needs to be checked. It was a long time back.
Well, are you aware of any documentary evidence which would support that? Are you aware of any?
Like evidence to prove again your question? Can you repeat it?
Are you aware of any documentary evidence whatsoever, could be an email, literally anything, which would support the fact that you have just said, sorry, the position that you have put forward, that Panther had planned to launch in November 2017?
Yes, we have the email communication with RERA. It also can be provided if it's required, obviously, yes.
Okay, well, we'll come to that the reference to RERA in a second there. Okay, but that's are you aware of any other evidence apart from that email communication?
Well, there should be more, but I can't remember for now.
Okay, well, if Mr. Dylan Malone is aware of any, I'm sure he'll take you to it. Now you state here, sorry, if I'll just go to, sorry, so to clarify, it is your evidence that the launch date was estimated to be November 2017. Now, you've referenced earlier that there was a feasibility study commissioned, wasn't there?
Yes.
Now, if you go to, I think it's at paragraph 28 of your witness statement. And you say here, we commissioned a feasibility study for a first rank entity, and the report delivered at the end of November 2017. Now, before I come to the timing of that, as far as I'm aware, you don't exhibit this report within your witness statement, do you?
No.
Where is this document?
It's available. It can be exhibited, and it was provided to the expert.
Well, I mean, we looked at the experts appendix 2 earlier in relation to the sources of information, and the 5 items that he says were provided by the client are project inventory details, project rental performance from May 2020, site affection plan, project brochure, and taking over certificate. He doesn't mention a feasibility report.
That's right.
Well, it's right that he doesn't mention it.
Yes, it doesn't mention it.
Okay. Do you not think it would have been important for this document to have been exhibited to your witness statement, given it supports your allegation that there was a plan to go, or a strategy to go off plan?
Yeah, I mean, it could be, yes.
Okay. All right. Well, let's say even if this document did exist at one time, if you had planned to launch in November, as you stated earlier, why did you commission a study which was only delivered at the end of November? Wouldn't it have been important to do that much earlier if you planned to launch in November?
No, it was done much earlier, but I think the final report was given us maybe in the November. I need to check this information exactly, but the feasibility study was done earlier than that.
Well, that's not what your witness statement says. Your witness statement says it was delivered at the end of November.
Maybe the final draft or something like this, because
Okay, well, you don't mention the fact that there was an earlier draft of it provided earlier, do you?
no.
When do you suggest that the earlier drafts were provided?
If my witness statement is mentioned end of November, that means when I did the witness report, I verified the date. So that means the report was supposed to state end of November.
Okay, so it was end of November then. There wasn't.
Yes, has to be, yes.
Okay, well, I'll come back to the initial question then. If you planned to launch in November, why did you commission a study which was only finished at the end of November? Surely you'd want that well in advance of when you wanted to launch. Would you agree with me?
No, I don't agree with you, because it's not just this one report we're basing our strategy and the plans on only. It was one of the greatly supportive documents. However, it was not the only document, and we did this internal study as well, and we checked with the market experts on their opinions, and it was a great opportunity. That's why we started.
Well, I mean, if this was delivered at the end of November, if you had planned to launch in November, you would effectively be launching before this report was due to you. So what's even the point of the report?
Well, this dates I need to check exactly. I mean, it's something that I don't think it has any value.
Okay, well, let's go to some of the other documentation in relation to this then. So you've said that you're familiar with the process for selling off plan, and it's right, isn't it, that before you can release units onto the market, a property has to be registered with RERA, and you need to get the individual title deeds. Would you agree with that?
No, that's not actually the correct sequence. Actually, first RERA requires the project to reach certain milestone. Once the certain milestone is achieved, RERA conducts an inspection and makes sure that the certain level is achieved. Only after that, they register the project, and once any buyers they start buying the units, they issue the individual title deeds for the end users or the investors. Okay,
well, let's go back then, back in the process. So go to paragraph 36. So that's page 272. Paragraph 36.
Yes.
Now you state here that on the 28th of November, you wrote to RERA in relation to the requirements. So you wanted to know what level of percentage you needed to have to market to present the units, to the market for off sales plans. Correct?
Correct.
Again, the same question, similar to the first question. Sorry, I've not seen a copy of this letter. And now again, Mr. Dylan Malone might be able to point me to it in the bundle somewhere, but I've not seen a copy of it. Did you provide it within these proceedings?
Yes, we did.
Okay. Well, I've not seen a copy of it. Anyway, in the 26th of December, so it takes RERA to about a month or so to come back to you and confirm what the percentage of completion was, or that would be required, and that was 50, correct?
Yes.
Okay, well, in relation to this, so the project period, are you aware, in this case was 16 months, and so as taking a very basic equation, 50% of the project would have been completed in March 2018. Would you agree with that? If there was no delays.
This detail is I need to verify this detail actually.
Okay, well, I thought it was a relatively basic question. 16 months divided by 2 is 8 months, and 8 months after the 11th of July would be March 2018, wouldn't it?
No, construction is much more complicated than dividing the project duration to 2.
Okay, well, okay, let's phrase it slightly differently then. It would be very, very unlikely that you would have been able to reach 50% within 3 or 4 months. Well, sorry, so it would have been 4 months between July 2017 and November 2017. So that would have been what's that? 1/5 of the project, 1 quarter. It would be very unlikely that you'd be able to reach 50% completion by November. Would you agree with that?
No, I don't agree on this. I mean, this needs to be verified exactly. The problem, actually, what the main challenge was for us as a client, because of continuous delays from the contractor. It was never clear when we're gonna reach the milestone, because we were given every time false promises, and every time they were breaking the promises. So it was very frustrating, very difficult for us, and actually it's also for us, even when we reached the 50% progress, I think it was much later than we planned. But the main problem was we were not confident that if we're gonna sell off plan and if we're gonna enter into agreements with our buyers, then we will not be defaulting as a developer, because if we entered, because of the past experience of seeing all the delays, and if we entered into agreements, it will even cause us more problems. We have a delaying site, never completing project, plus we have claims from the purchasers that the project is being delayed, and this is what we didn't want to be in this situation. And in the end, it was a sensual decision, actually, not to risk and not to go for that, because in the end, you see the result, how the project ended.
Well, Mr. Prajiev, that was a very, very long answer, but not an answer to the question. The question was, do you agree that by November 2017, it would have been near impossible to have reached 50% completion? Would you agree with that?
I disagree with that.
Okay, well, we've got your evidence on that. Before I move off this point, you stated earlier that, in your witness statement, what we referred to earlier, when you wrote to RERA, although we've not seen a copy of the letter, but assuming that this did take place, you wrote to RERA on the 28th of November, and that's when you wanted to confirm whether it was going to be 20% or 50%. That's correct, isn't it?
Yes, because sometimes RERA, depending on the project and the size and the different conditions, they give different requirements. But for our project, they requested 50%.
Now, wouldn't that, if you had planned to launch in November, wouldn't that have been very, very important information for you to have known about? Because it would have determined when you could launch. Would you agree with that?
Of course.
Well, if you planned to launch in November, why did it take you until the 28th of November to write to RERA about it?
No, see, there is no point to write to RERA if we have ridiculously low percentage on site. I mean, there is no point to waste time and go to approach the authority, because anyways you're gonna get a rejection. The whole point of approaching 28 November, at least some activity started on site. The MESC started to do some structural works, like at least we could tell the authority, please come and see, and is there any opportunity to start? Because earlier than that, there was no point. The RERA will simply say, like, why are you wasting the time?
Well, I suggest to you the fact that you only wrote a letter on the 28th of November clearly illustrates that you were not preparing to launch in November 2017. Would you agree with that?
No, that's I completely disagree with that.
You state, moving on slightly, you state in paragraph 37 of your witness statement that you received an unsolicited offer. do you exhibit a copy of this offer to your witness statement? Sorry, or have you sent in a copy of this offer at all?
No, we didn't actually. The offer was confidential. But we just brought it as a fact that we had a solid offer from a fund and DFC, very reputable fund. But we couldn't proceed with it because, again, for the same reason of the delay. And the fund had very strict requirements. They wanted a very strong sales and purchase agreement, where they had very strict penalties, and we couldn't risk.
So moving on slightly, in paragraph 40 of your witness statement, you state that we did not plan. You made the decision to not go off plan in November 2018. Do you have any written record of that decision, as far as you are
aware? See, I mean, it's an internal decision. It was an internal decision because of the state of the project, and then I mean, we had so many notices to the contractor. We had so much communication. I mean, what else is needed? It's all recorded. We can see the progress, how the progress was in November 2018. Obviously, we couldn't sell it, and it was a sensual and correct decision. That actually in the end we end up with the termination and with the blackmail of the contractor that the project will never be ended even.
So is it right to say, Mr. Pragiev, that there's no documentary evidence that you've produced at all of any plan to go off sales in 2017 or the change in that decision? There's just no evidence supporting what you stated in your witness statement. Would you agree with that?
I didn't understand your question again.
Sorry, would you agree that there's no documentary evidence supporting what you've set out within your witness statement about the plan to go off sales and then the change in decision of that plan? Would you agree with that?
Well, I already said earlier that we have exhibited the documents to the expert, but in 2018, no, we didn't have any documents, but it was an internal decision. I mean, because of the progress on site.
Okay, I'm going to move on to a different topic now. I think we've got your evidence on that. Paragraph 48, you discuss the costs of completion.
Yes.
And you confirm that there is over 9.4 million incurred for the cost of completion. Are you aware that your own expert, Mr. Allen, has cut this figure in half in terms of recoverability? Are you aware of that?
I have seen the report of Mr. Allen. However, these are the actual expenses, and we have all the proofs. We have invoices, we have the receipts, and these are actually the amount which was paid. But again, the expert has his right to assess it, and I think I will not comment that.
Okay, well, we'll explore that issue more in expert evidence. It's right, though, that this figure includes sums for allegedly defective work, but are you aware of any evidence which details the actual cost of the defective work, independently of the cost of completion?
Well, we should have a record on that, but in terms of, I think, the construction site, Mr. Resk already addressed all your questions, and if you have more, then you can obviously ask him as well these details. But from my side, I can confirm that these amounts were incurred. We paid this amount, and actually the payment proofs are available, and it was submitted.
Okay, I'm going to move on to another item of quantum. And this is in relation to the company overhead. So if you go to paragraph 56A.
Yes.
So you state here, in relation to company overheads, as a consequence of MESC delays, it's necessary for Panther to divert staff from other business activities. So in relation to this, and I think there's a claim of 2 million. Now, I just wanted to clarify, if we go to Mr. Singhaal's second report on this, and this is at page 858, so that's bundle C, document 10, and then page 858.
Okay.
Sorry, document 13, not document 10, apologies. 1 second. And so we can see here in relation to the very bottom here, we can see in relation to company overheads, states that Mr. Allen is focused on an amount corresponding to 56,600 debited on a monthly basis. And then if we go down towards the bottom of that page and the top of page 859, okay, and you can see here, Panther have advised that the salary cost relates to Mr. Bagitov and Ms. Consula Galina. So is it right that this amount of 56,600, this is to 2 employees of Panther, is that correct?
That's right.
And this is the general manager and the manager of Panther, correct?
Correct.
Presumably, Mr. Bagitov and Ms. Galina were employed by Panther before 2018, weren't they?
They were, yes.
And are they still employed by Panther now, to your knowledge?
Yes, they are.
Panther was incorporated for this project only, and it only ran this project during this period. That's correct, isn't it?
Yes.
And so Mr. Bagitov and Ms. Galina were allocated to this project regardless of what else went on. Would you agree with that?
Correct.
And would you agree that they would have been working on this project through to completion and during the defect liability period in any event? Would you agree with that?
Here in this point, I disagree with you because if the project was completed on time, obviously they could. Panther had the plans to do another developments, and they will not be incurring the because of the delay additional costs.
But the delays would have been primarily before completion, before termination, wouldn't they? Would you agree that regardless of whether the delays occurred or not, Mr. Bagitov and Ms. Galina would still have been working on this project during the defect liability period?
If it was a normal case where there was a main contractor, and if the project is over and there is another project starting, yes. But obviously in current situation where actually the contractor was terminated, there was nobody to coordinate, nobody to do the coordination for defects and liability period, to do the contractor's job. This is obviously a prolongation and extra cost of the company, and this actually was paid and it is there.
Well, I suggest to you that Mr. Bagitov and Ms. Galina would have been employed and working during this defect liability period, regardless of the termination. Would you agree with that?
No, I disagree.
In your witness statement, you mentioned about Panther having to divert staff from other activities. But given that Panther was solely incorporated for this project, certainly prior to termination, they wouldn't have been diverted from any other project, would they?
No, it's not the case. Actually, the Panther was had plans to do more projects, and obviously due to delay and termination, it couldn't develop other projects. So. In fact, yes, it is the only project, but it's not because it's not a choice.
Okay, have you provided any evidence of the other projects that Panther were going to be working on but couldn't because of the alleged delay?
No, I didn't.
Okay. The next item related to these company overheads. So if we go to it's page 409, so that's bundle C, document 6, page 409. So this is a table that was prepared by Mr. Allen in his first report. And these are the, you can see these are the various claims that have been made by Panther. What I'm interested in is if you look at item 5, and there's a claim here for office rent for a full year and 10 months. Correct?
Yes.
But in fact, well, why is this just from September 2018? Why is this not from earlier if the project should have finished? Sorry, actually, the project should have finished in November. Would you agree that there is no entitlement to claim from September to November of that period?
September to, but these amounts are from the delays considered only during the delay period. Whatever expenses are given, they're purely are for the delay period.
Let's just clarify this, sorry. I just want to look at this item briefly. So it says Creative Zone office rent for full year 1115000. Okay. But then the amount that's actually being claimed is only 958833. So it's only 10 months that's being claimed. Is that correct?
That's correct.
Why is only 10 months being claimed when the delay was allegedly 16.5 months?
Because the Panther rented only for 10 months. Then after 10 months, they moved out from the office. So there was no actually more expense. So they didn't claim for more expense because it was not incurred.
Okay, thank you. If they moved out of the office and therefore didn't need it, would you agree that it suggests that this expense wasn't necessary?
No, I disagree.
Just in relation, while we're on this document, I just want to look at some of the fees, so the trade license fees, which are at actually, I don't think they're on this document. Sorry, yeah, they're at the bottom of the overheads. So you can see in relation to the overheads still, you see all these various fees that have been incurred, trade license fees, PRO fees, sponsorship renewal fee, correct?
Yeah, and these are very minimal amounts. I mean, we're talking about the major amount is the salary and few government expenses and the office. Nothing else is there.
But wouldn't these fees have been incurred in any event? Because Panther needs to have all of these fees, regardless of whether there was delay or not.
I believe I already answered this question earlier.
No, I think I was talking about office rent in relation to these license fees. So from item 6 down to 9 and item 3 and 4, wouldn't you agree that these fees would have been incurred regardless of the delay?
No, I disagree. It's the same as the salary. So it's all the same expenses. So it's company overheads, regardless it's a salary or company renewal expense or rent expense. These are caused all during the delay, and we are not claiming for anything extraordinary. I believe this is very genuine and actual expenses.
But Panther's still in existence today, so it's still incurring these fees, correct?
Yeah, but we are not claiming now. I mean, once the DLP is over, it's over, finish.
But it would have incurred these fees regardless of the delay or not, wouldn't it?
No, I disagree with that.
Briefly, I want to discuss the town development management expense, and so this is a Town X real estate company, as I understand it.
Correct.
Now, you allege that these are related to the delay, but these are incurred from June 2020 onwards, correct?
Yes.
Are these related to the rental of the property?
No. This is related to the to assisting during the the project for the construction and the and supervision of the construction.
Supervision of instruction.
Supervision, management, and yes.
Even though that's all after completion, correct?
What do you mean after completion?
Well, the project was completed in May 2020, wasn't it?
Yes.
So these are all incurred after the project had been completed.
Well, it was paid after, but the actual services was done during the construction. And I think it's clearly highlighted in the invoices and in the details of this payment.
Okay, well, we'll explore that in expert evidence. Moving on to the audit, and I think you state in your witness statement that the audit was due to the delay and poor quality of the works, and so you needed to assess the quality of the MEP works. Well, if that's correct, then surely the audit's related to the defects, not the delay. Would you agree with that?
It's actually both, because MESC, the main contractor, has changed the MEP contractor 3 times. Allegedly, I think they changed it 4 times because, but actually there was officially 3 companies. So they changed them 3 times, and it's recorded. So one contractor came, then they abandoned, then another one came, then like it was a long story. So we as a client, we were not confident on the consequences of this delays and the changes of the MEP. So we hired a MEP specialist for a very small scope, just to come and make sure that during this change, if the what's the effect? Was everything missed, or like in general it's purely because of the delay and the quality concerns?
Now, as I understand it, this report hasn't been provided because our expert certainly hasn't seen it. Why wasn't it provided in these proceedings?
I think we provided it.
Okay, well, if I'm wrong on that, then I'll be corrected. The invoices for this, though, we can see from this page, we can see that the invoices for the audit are in 2019. So this was before the MEP works had even been completed. Would you agree with that?
No, MEP works usually start from very early stage, from the foundations, where they need to lay out the sewage pipes and other things. So, no, I disagree with that.
Well, the MEP work, so you're suggesting that they probably would have been completed by this time?
No, that's not what I'm saying. I'm saying that MEP works start from very, very early stage of the project and continues until the completion of the project. This is what I'm saying. And obviously we did the audit just to make sure that all this change of contractors and delays, we are not getting anything hidden inside and some outcome from it. So this audit was purely just to assess.
Okay, well, we'll discuss that further with the expert. The valuation reports, briefly, is this the Savills report?
No, that's GLL, Jones Lang LaSalle. That's another report we have done when actually the delays started from MESC. We also wanted to know like what's the impact where we are and to verify these numbers. And why we put these expenses, because we will not do this study unless there was a delay, and we wanted to assess the impact of the delay.
Okay, again, and it might be that it is somewhere in the bundle, but is this report disclosed as far as you're aware, this JLL report?
As far as I'm aware, yes, it was disclosed.
Okay. If we go to the utilities, again, you can see on this page, I just want to look at item 39 and item 40. Trackees payment for green building certificates and trackees payment for final inspection.
I'm sorry, where we are? Can you?
So this is on page. So I think we're on Mr. Allen's report still, page 409. Have you got that?
409. Okay.
And you can see item 39 and 40.
Okay.
It's a point that we'll be dealing with an expert, but I need to put it to you. I'm going to suggest to you that these items are not recoverable. Do you agree with that?
That's usually paid by the main contractor, as far as I know. That's why they're here. But this needs to be checked. I can't answer this in detail.
And briefly on 43 and 44, so these are DEWA consumption charges. Wasn't the project completed on the 1st of May? So why are DEWA charges from May 2020 being charged?
No, these are actually the payments. Usually, how it happens, the bill for any electricity and water bill is billed after the month is complete. So you usually receive, if, for example, the May expense you receive in June. So these are actually the expenses before the completion of the project, and usually which is paid by the contractor. It's cost of completion.
Okay, moving on, just in relation to the engineer's supervision fees, so we still got those up here, items 60 to 63.
Items 16?
60 to 63.
Okay.
So we can see here there's charges for ProLead and then NACIL, correct?
Yes, that's right.
And we see in 62 and 63, there's charges for a revision of a design and a resubmission variation. How are these related to breaches caused by MESC?
So if you can see, the NAGA payments supervision is for December, January, and February. There is no for March. There is no for April, although the project was completed in May. So there was some outstanding amount for NAGA to be paid, and obviously it's some other expenses which is related to NAGA scope. So this was paid to the company who finally assessed and for MEP. So it's actually, we are not claiming from here for March and April, although these expenses are incurred, like the consultant was until the completion of the project. But these are small amounts, and
well, just because they're small amounts, they still need to establish that they're recoverable, Mr. Prozhiev. They're dated much later as well, so especially the NACIL ones, 2021, that's quite a long time after completion.
That's
From
correct.
what I can see, it doesn't appear to be related to anything to do with MESC. Would you agree with that?
This needs to be verified. I can't answer it now. I mean, it's very small figures, and it needs to be. But because, like, actually, what I can confirm now is these expenses were incurred. These were project related, but like the detail exactly why it is here, it needs to be looked at in detail.
And just a couple more questions. In your witness statement, you refer to the selling of scaffolding and other materials left on site by the contractor for 80,000 dirhams. That's correct, isn't it? You recall that? I can take you to it if you need.
Yes, please.
Okay. So it's at, 1 second. Apologies, I think this actually might be in Mr. Rezek's witness statement as opposed to yours. One moment. Okay, we'll leave that point. Finally, I just want to address your second witness statement.
Well, as far as I can see, this hasn't been uploaded yet.
Well, Your Honour, do you have a copy of it? I don't.
No, I don't have a copy of it. It's not been sent to me.
Hello, I'm told that it has been uploaded. You might need to renew your access, but it's pages 12850.
12850.
And then the witness statement is just those two pages, 850 and 851.
All right, give me a moment. I'll go back and I'll reload.
And then exhibit AA2 is on page 12852.
Yes, okay. Okay. Well, I'm looking under the heading evidence.
Yes, I'm on page 12850. I'm looking at it, and 12850.
All right, wait a moment. Yes, I've got it. I'll just have a very quick look.
Thank you.
Yes, thank you. Carry on, Mr. Barrow.
Yes, it's just a couple of brief questions, Your Honour. The first point is, I just note that within paragraph 6, he states Panther will furnish the court with copies of invoices and its corresponding receipt of payment. So these haven't yet been provided, have they? Sorry, Mr.
It has been provided.
Okay, well, it says that they will furnish, so I've not seen that yet. It seems from the witness statement. Okay, well, in any event, this issue is going to be subject to legal submissions in relation to their recoverability. So I won't push those questions onto you. Your Honour, those are all the questions that I have. Thank you
Well,
very
thank
much.
you very much, Mr. Burrow. Re-examination?
Thank you, Judge. I just have two questions.
Yes.
The first is, if Mr. Akpaziev, could you please tell the court what your relationship is and your role is with Townex?
So I'm a partner in Townex Real Estate Development. I'm 50% owner of the company, and Townex was contracted to help to develop the to complete the project actually for Panther.
Yes. And do you have any directorship or management role in Townex?
Yes, I hold a managerial role in Townex.
I'm sorry, you hold a what did you say?
A manager's position at Townex.
Well, are you on the board of directors?
Yes, I am as well.
So you're a director?
Yes.
And a manager?
Yes.
Okay.
I was going to finally ask about that last point on your second witness statement, Mr. Akpaziev. I think if you read down to paragraph 6, if you read carefully paragraph 5 and 6, you were asked whether certain of the invoices were missing.
Correct.
And you see, you've exhibited the spreadsheets reflecting the fees collected by Altamimi.
Yes, we provided all the invoices and all the proofs, all the payments for all these court proceedings. And just to add why we brought this actually to the attention of the court, because in general it was such a bad behavior from MESC. It was unlawful. I mean, this was a continuous actually attitude of MESC. Actually, we faced very similar attitude during the construction with all this MIU proposed, with all the blackmail. Like, in my opinion, why will a contractor, if they believe that they don't have a right for they do have a right for an extension of a time, why will they come and propose an MOU with the new terms and with the condition? They put it as a condition to the client, saying that if you don't sign this agreement, if you don't waive the delay penalties, if you don't waive general damages, then we will not proceed with the work. You will not get the project. It will be open-ended, and it was a clear blackmail. And after we decided,
well, I think
Mr. Akpaziev, I asked just specifically in relation to the question of the fees, and you're prepared to furnish the extra invoices that are missing with the non-relevant pieces redacted.
Removed.
Is that correct?
Yes. It was already provided, but Your Honor, what I wanted to also highlight is when we actually, after the termination, MESC opened 4 cases in Dubai courts. It was complete.
I've read about this in the opening.
Yep.
So I'm aware of.
Thank you so much.
Of this part of the whole story, I can assure you.
Thank you. There's no more questions.
Right.
Well,
thank you very much for your evidence. And I release you as a witness. You're free to go.
Thank you so much.
Now,
thank you, Mr. Akpaziev.
The final factual witness is Mr. Is it Al-Kurdi or Kurdal? I can't make it out. What's his name?
Mr. Al-Kurdi.
It's Kurdi, Mr. Al-Kurdi. Now, Mr. Burrow, doing the best you can. This is a question for Mr. Dillon alone. Doing the best you can. How long do you think you're going to be with this man?
I think maybe an hour, but maybe less.
All right.
I could be much quicker. I mean, it really depends on.
It could be an hour.
On how much dialogue we have.
Okay. And the the target is to finish the factual evidence today. Is that right?
Yes.
And then we have tomorrow, we have the experts. Well, now, in Dubai, it's 5 minutes past 4. Is that right?
That's correct.
And I think the court can be persuaded to sit until, say, 4:30, maybe a bit later. I would like to have a quarter of an hour's break now. And it seems to me that we should be able to finish this witness when we start in quarter of an hour's time. Are we agreed on that prognostication?
Yes, indeed. And when you spoke about 4:15, I think is that UK time? Or when you said you
Well, at the moment it's 1:05. So it's 1:05.
Yes.
So if I add 3 hours,
Yes.
4:05 in
I
Dubai.
see. I see.
That's
But I'm confident we will comfortably finish Mr. Al-Kurdi today, I believe.
Okay. Well, we'll start at 25 past the hour with the cross-examination of this witness.
Thank you.
Mr. Burrell, understood?
Yes, Your Honor.
Yes. All right. 25 past the hour. Thank you very much. Yes, we're ready to go.
Yes.
Good
afternoon.
Mr. Burrell?
Yes, Your Honor. I think Mr. Al-Kurdi is there.
Yes.
It's just his video was on earlier.
Right.
Yes. I'm Abdulaziz Ibrahim Al-Kurdi.
Well,
Mr. Al-Kurdi, would it be possible to get your video switched on, Mr. Al-Kurdi?
Are you hear me?
We can, yes.
Okay.
Mr. Al-Kurdi, could
Yes.
you switch your video on?
Okay. I'm Abdulaziz Al-Kurdi. I am working in the MISC above 25 years. And I am my position in company projects director.
Mr. Al-Kurdi, before you go on,
Yes.
greetings. It's good of you to be here to give your evidence, but I have to be able to see you as well as hear you. So I wonder if you could make sure that your video camera is switched on.
Now, okay.
Ah, yes. Yes, now I see you.
Okay.
Thank you. Now, just a few words of introduction.
Okay.
Witnesses give their evidence on oath in this court. That means a solemn promise that the truth will be your evidence, that your evidence will be completely truthful. The promise can be made on a holy book, or it can be a secular oath. The court makes no distinction between a religious oath or a secular oath. What oath would you like to take for your evidence?
What I like it?
What oath would you like? Would you like to swear on a holy book that your evidence
Yes.
is true?
Yes, I will swear holy book. I have my holy book. I swear
Is that
my
the
holy
Quran?
book. Quran, yes.
Yes. Would you just hold it in your right hand and listen carefully to what I'm going to say?
Yes.
I solemnly and sincerely swear on the holy book of the Quran
Yes.
that I will give evidence which is the truth, the whole truth, and nothing but the truth. Is that the oath you take?
I do.
Thank you very much. That's the oath dealt with. And now Mr. Burrell will introduce your witness statements, and then you'll be asked some questions. Thank you very much.
Thanks. Yes.
Mr. Burrell needs to unmute.
There we go. Thank you, Your Honor. Mr. Al-Kurdi, do you have a copy of your witness statement in front of you?
Yes, I have copy, yes.
Could you go to the final page of that witness statement?
Yes, final page, yes.
Could you confirm that that is your signature?
Yes, this is my signature. Yes, correct.
And can you confirm that this witness statement is still true to the contents of this statement are still true to the best of your knowledge and belief?
Yes.
Thank you. Your Honor, I ask that this statement stands as the claimant's evidence or the witness's evidence in chief.
Yes.
Thank you. Mr. Al-Kurdi, if you wait there, my learned friend, Mr. Dylan Malone, will have some questions for you.
Okay.
Thank you, Mr. Kurdi. Mr. Kurdi, I see in your oath at the end of your witness statement that you've taken care to tell the court that some of your evidence is based on the documents and exhibits, and some of it is based on your personal knowledge. Isn't that right?
Okay. Right.
Yes?
Right.
Yes.
Yes.
And I think you've said specifically that paragraphs 3 to 17 of your statement and paragraphs 19 to 23 are based on the documents exhibited to your statement.
Right.
Is that correct?
Right. Correct. Yes.
Yes. And that's because you are head of projects. You're in a senior position in MESC. Isn't that correct?
Why?
I say the reason that you're saying that you're relying on the documents is because you hold the position of head of projects in MESC,
right.
and you have senior responsibilities.
Yes.
Yes, and therefore, yes, and therefore you can't be expected to know every detail of all the construction works.
No, but I'm aware of every detail because our team here report to me. I am aware and everywhere. Yes.
Very good. But you couldn't, for example, be expected to know about all the variation requests.
About variation, we have our team, he do it variation and he report to me. I am aware and he will submission to consultant or to engineer for he take it approval. Very
good. And similarly, in relation to the extensions of time, then you rely on the MESC personnel who report to you and inform you about the extensions of time.
Yes, right.
That's right. So that you're relying both on what is reported to you and you're relying on the documents.
Right.
Very good. Okay. So, for example, in relation to your witness statement, and you'll see, for example, at paragraph 6, you list 14 delay events.
Yes.
Yes. And are you aware how many of those delay events were the subject of request for an extension of time to the engineer?
Okay, this one will have 14 reason, 14 letter we issue to consultant, but we submission extension of time 4 times to consultant.
Okay, so I think when you mention 4 times, you're speaking also about the 4th one, which was issued in January 2020, isn't that right?
Right.
And that was after termination, isn't that correct?
Right.
Yes. So there were 3 extensions of time that were made during the contract before termination.
Yes.
Yes. And in those 3 extensions of time, I'm asking you, do you know how many of the delay events that you've listed, the 14 delay events, how many of those had been addressed by the engineer? Decided by the engineer.
Decided by engineer?
Yes.
Engineer, he rejected of all. When we submission, immediately he rejected as consultant, as engineer, he rejected. Why?
Yes.
If you want listen why or no?
Not for the moment.
Do not ask me why.
I'll ask you why in a minute. Let's talk about the causes of the delay.
Yes.
Actually, that's a good point. Let's go to the table at
Yes.
paragraph 8 of your witness statement. You see the table,
Yes.
and those, do you know if any of those days, those calculations, take account of a float?
This calculation happened by our engineer with expert. This one related to our claim for time.
I
What we
see.
said in the number 1, number 2, number 3 different day. Number 1 already we have in number 1 we have 62 day. Number 2 we have 132 day. And number 3 we have 298 day, and number 4, what you say, we keep it after termination agreement. We make it on time, but we hold because we keep it good relationship with partner. We try solve it a problem between us, but we submission after termination agreement. You are right. In this extension of time, we have total our recommended 415 day. 415 day.
Okay, Mr. Al-Kurdi, thank you. So you've mentioned that this was based upon the claim and based upon calculations made in support of your claim for an extension of time. Is that correct?
Yes.
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 And do you see, and I think the numbers then that you are reflecting here, do you know whether any of those numbers take account of the float in the construction program?
Okay, this already we make it related to this one. We have our team, we have planning engineer, he have a Bravimera programming, he do this analysis and he sent it to consultant.
Okay, who was that engineer?
Our planning engineer in our company, Engineer Ayman Haridi.
Yeah, and who did he send it to?
To consultant, to Naga consultant.
I see.
Through project manager, and go to Mr. Mustafa
Yes.
Rizq.
Okay. And does the table at paragraph 8 give any reason for the delays? Is there any description of the cause of the delays in paragraph 8 of your witness statement?
Okay, we have 14 reasons. We have 14 reasons. You would like listen from me one by one?
No, I'd just like you to please answer the question. In the table, I cannot find any description of the cause of the delays. Would you agree with that? There's no description of the cause of these delays in the table at paragraph 8.
What do you mean the table?
If you, in your witness statement, are you looking at your witness statement?
Yes.
And you see the table, it's like the columns.
Yes.
In paragraph 8.
In paragraph 8 of your witness statement.
Okay.
Yeah. Is there any, I cannot find any description of the causes of these delays, of the reasons for these delays in that table.
Okay. You will not find any clauses.
Can you please answer that question first, please?
I assume you agree with that, because as we look at it, we can see the dates and the days and so on, but it doesn't set out here any of the causes of the delay that Maersk relies on, does it? Just look.
Okay.
Yeah. Now you're going to be asked some more questions, and you'll have your opportunity to deal with your case about it. But what the lawyer is doing is he's taking things step by step. And the first step is that there's nothing about the causes of the delay in what we see in paragraph 8. Go on, Mr.
Thank you. Do you agree with that, Mr. Kurdi, that there's nothing from this table that we can see that explains the delays?
Yes.
Yes. So it's not true to say that the table explains the delay. It doesn't explain the delay, really.
Okay. Before this schedule, you see, we are writing all what the clause is there in our agreement, sub-clause and all in our agreement.
Okay.
Already we mentioned.
Yes. Very good. Let's look at that. So you're referring to paragraph 7, and in paragraph 7, you very fairly say subject to subclause 20.1. You see that in the second sentence, where you say subject to subclause 21.1. Yes. Have you read the contract?
No, here.
I'm sorry, Mr. Al-Kurdi, please. Have you read the contract?
And I am not contract manager. I am as a supervision. I am not reading one by one. Already we have team. Already he do it.
Well, please just you either have read it or not. If you haven't read it, simply say so.
I read some clause when we have anything we discuss. Yes, I will read. Of course, I have contract, but I am not reading contract fully as wholly and will be follow one by one. This one do it by our specialist engineer, and he do it and he give me a report.
Very good. Do you know what subclause 20 says in the contract? Are you familiar with subclause 20?
No, now I don't know.
Okay. Well, does it surprise you to know that subclause 20 provides for a mechanism for determinations in the event of a dispute? So, for example, if you disagree with the engineer, and if you disagree with the engineer's determinations, you must then take it further. Does that ring a bell?
No.
Okay, so are you saying that you weren't aware that you had an obligation under the contract to escalate your complaint in the event that you disagreed with the engineer?
Right.
Did you know that or not?
This not my scope work. We have somebody, he follow up and he do it.
Very good. Well, let me just show you a few clauses in the contract. If I could ask you please to turn to page 88 in section B. And you'll see at the bottom of that page, at clause 3.5, you'll see there's a reference to determinations, and the engineer makes a fair determination in accordance with the contract, taking due regard to all the circumstances.
Please, you can go slowly. I try
yes,
to open
of course.
this one, section B. Which clause?
3.5, page 88, the bottom of the page.
1 second, please.
If you go to there's a box called find page, and then in the box beside it, if you put in 88.
Page 88, 1 minute, 63, 88, section 3.
Do you see that now, Mr. Al-Kurdi? At the bottom of the page.
I try go to this one. I will see now in 74, 75. Please, 1 second.
Are you working on a link to the court system, or are you working on something on your laptop?
now I'm in laptop. I am open this page now. In you tell me 78 now. You tell me which number please
88.
again. 88.
Page 88.
1 second. I read this. 82.
This is
Yes, yes, now I'm in 88.
okay,
Yes.
very good. Thank you. Now, if you go to the bottom and you'll see the very last sentence on the page, after the engineer gives a decision, a determination, it says each party shall give effect to a determination unless and until revised under clause 20. So when we look at, there's another amendment to that on page 203. So could I please ask you to go up to the box on your system if you're linked into the system and put in page 203.
Yes.
And then click Find Page once you've done.
And then click the Find page. Thank you.
Okay, continue.
Thank you. And you'll see halfway down page 203, there's an extra agreement on determinations where each party shall give effect to each agreement or determination unless one party notifies the other of his dissatisfaction with a determination within 14 days of receiving it. Either party may then refer the dispute to be settled in accordance with clause 20. Do you see that? So this means I'm asking you to agree that MESC had to give effect, it had to respect the engineer's determinations unless it gave a notice of dissatisfaction within 14 days of that determination. Do you accept that?
Again, a question, please.
Do you accept that MESC, after the engineer had made his decision on the extension of time applications, had an obligation to respect the engineer's determination unless they made a grievance, unless they expressed dissatisfaction under the formal mechanism within 14 days?
Okay, I respect, of course I respect.
Okay, thank you. And do you also accept that an extension of time under the contract, an application for an extension of time must be brought to the engineer, and the engineer in the first instance must be asked to rule on whether there is an extension of time or not?
Yes.
Yes, and that's in the contract. So in this case, I've said to you that I asked you whether all of the 14 delay events that are in your witness statement had already been decided by the engineer, and you said all of them. I think the correct position may be that 12 out of the 14 were decided by the engineer. So all of them except number 1 and number 14 in your statement, and I hope you can take my word for that. But what I'm saying to you is, do you accept, therefore, that when the engineer had made his determination on those 12 delay events, if you disagreed with them, you should have brought the matter further, you should have expressed dissatisfaction?
Okay, I agree with him. We try many times, we meeting, we try discuss, we try explain to him, but finally, the engineer decision, this not do by him, do by this Mustafa Rizq. He is as a client representative. This reason we try explain to him, we try respect each other, we try explain, but finally we respect. Anything in agreement, we have no issue.
Very good. So what you've just fairly said is there was a process of engagement with the engineer and he decided against you after that process. Is that correct?
Yes.
Yes. And then in relation to numbers 1 and 14, the delay in the receipt of the demarcation certificate, do you
Yes.
know whether you ever made it? Did you ever make a request for an extension of time on that basis because of
Yes.
the demarcation certificate? Did you ever approach the engineer about that?
Okay, I can explain about this story. When will be signed contract, what we put commitment date in our contract, when will be signed contract. But we sign contract, we are not working alone. We are respect government regulation and municipality regulation. When will be apply to municipality for take demarcation, for some reason by government for this line, we find demarcation certificate from municipality after 2 months. This delay, this not happened by us. This delay happened by government, by regulation. Yeah,
And
when will this start?
whose risk is that delay under the contract?
Sorry?
Whose risk is the government delay under the contract?
This commencement date must be as FIDIC, as regulation here, local regulation must will be when taken officially from government. How we can start work in the site without demarcation certificate? If government, the municipality not give demarcation, how I can start work? This one must be a consultant and owner, he understand. And we cannot do anything. How, where we can put it our
when
material
did you,
and our thing? How
yes.
I know where is our
Well, when did you become unhappy about this? And when did you raise it with the engineer? Did you ever raise it with the engineer?
And same time, we send it letter to him. We have a reference letter. We tell him we collected our demarcation certificate.
I'm sorry, it's gone. Mr. Al-Kurdi has frozen on my computer.
Yes, he has on mine.
Likewise on mine.
Do you know where he is, what jurisdiction he's in, Mr. Burrell?
He's in Dubai, Your Honour.
He's in Dubai.
He's he's at Albana Advocates law firm.
Okay. Well, a representative of the firm who's presumably looking in.
I'll look into it now. Yes, Your Honour.
Yeah.
We'll ensure. I'm being informed that the Wi-Fi, there's an issue with the Wi-Fi, and there's possible you can give evidence by phone, but I think we're going to just try and re-establish the link because it's much. I don't think you can do it by phone. We need him to be on the laptop for the, especially for the documentation. So I think it might be prudent just to take a 5-minute break, perhaps.
Well, you know, this is very unfortunate indeed. I would have expected the technology to be up to the task.
Sorry, I'm just being instructed. He is back, as I understand it. So hopefully he might be joining us in any minute now.
I am so sorry. This Wi-Fi disconnection. I am sorry, huh?
Yes, well, it's not your fault, Mr. Al-Kadi, and we'll do the best we can. We didn't hear a great deal of what you were saying, and I think perhaps Mr. Dylan Malone might put his question to you again, and we'll then hear your answer. Thank you.
Well, yes, my question originally was that whether you had when did you first become dissatisfied with the demarcation certificate, and when did you raise it, if at all, with the engineer?
Yes. This here as the local role with municipality, with government, we cannot start any work only after we take demarcation certificate.
I'm sorry, Mr. Al-Kurdi, I must interrupt you. Please answer the question. When did you raise this with the engineer?
Yes, we sent it to him and he is rejected. What I told you, in our extension of time, when will be sent it to him for anything, immediately he rejected. What I can do?
I see. I think you may be mistaken, and we won't spend too much time on it, but I have to suggest to you that you're mistaken, and that the demarcation certificate was never the subject of a request for an extension of time.
You take example for our delay. When will we say we have 14 reason for delay? This number for delay. We start project after we put commencement date. We start after 2 months. We sign contract in July. We take completion certificate in the 20 September. This reason, this out our control.
And I have to suggest to you that number 14 in your witness statement, the late nomination of the subcontractor for the ID works, similarly was never the subject of a request for an extension of time.
In our 14, the clause number 14?
Number 14 in your witness statement, yes.
Paragraph 6, the last one.
Paragraph 6. Do you know, Mr. Kurdi? It's all right if you do not know. I'm suggesting to you that 12 of the 14 events that you've identified were decided by the engineer, either in the first, second, or third determinations, and that the first and 14th were not. If you do not know, that's all right.
Yes. Now in this 14 delay reason, again, I not understand your question, please.
My question is, do you know when you first raised this as a complaint?
Yes.
And did you ever raise it with the engineer?
No.
No, okay, thank you. So in the period when the Memorandum of Understanding was being discussed between MESC and Panther, the focus, I think it's fair to say, the focus was on finding a commercial solution to having a realistic program. Would you accept that, a realistic program?
In the Memorandum of understanding. Yes.
Yes. And so at that point in time, in July, August, September, October 2019, when you were
Yes.
focused on
Yes.
trying to find a solution,
Yes.
were any of these delays, any of these 14 delays, were they ever the focus of your discussion?
Yes.
Did you keep complaining about these delays during that time?
Of course. Of course, for what we make memorandum of understanding, we discuss about the all reason. This 14 reason will be accepted both party. We start this negotiation in the August, July, August, and we accepted will be forgetted all this one, and we make it memorandum of understanding with a program for to complete job, for to complete handing over project in 30 December. And why he accepted? He accepted related to this reason. We have 14 reason, and for delay project, he accepted, and we make it this one, and we send it to him in the date of 11 September. For we put it all reasons this one for many reasons. We discussed focused for this one, and the client with his engineer, he is accepted.
Who accepted? Who accepted?
Client, Mr. Abul Qasim and Mustafa Ruzq. We made in the site today, and we review all this issue, what happened, and we accepted both party forgetted what delay happened, and he asked, we give him a program to how will be complete the project, and we are agree. Under this verbal discussion, we working 2 months, September and October.
Okay. Perhaps I can ask you, Mr.
Yes.
Al-Kurdi, to look at page D903A. Can you pull up D903A, please?
Where in my statement, or where was which one's this page?
No, it's in bundle D, in the section D of the bundle, at page 903, small a. Now, I think this is a letter from MES. Can you see it?
I try open.
Well, if you put in the
Yes,
little
you can
box,
ask me, please.
can you
Yes.
see the document?
Do you see the document? Mr. Al-Kurdi, can you see this document?
I try open this document.
Can you direct him? Can you see anything on your system which, can you say, click OK?
Still not okay, but you can ask me.
Well, I have to tell you that this is a letter from
Yes.
MESC dated the 6th of July 2019, and the third extension of time determination had already been handed down by this time. I think you're aware that the third extension of time determination had been given by the engineer on the 27th of June 2019.
Right, 27 June, right.
Yes,
okay.
yes. So on the 6th of July, you wrote to my client and you said that because of your disagreement with the extension of time, application approvals that you've been looking for, that you would serve notice for a slowdown on the site at that time. So you were threatening to slow down works on the site at that time. Is that correct?
Is this not correct? We not slow down, will be say slow down, not in this date. This is not correct. Our slow down will be say we are slow down after this one, not in this 6th July. In 6th July, we never say slow down.
Okay,
Well, I'm
very
sorry, Mr. Kurdi, but this letter that came from your company says
Yes.
this. Therefore, we would hereby serve a notice to slow down the works at site. Nothing could be clearer on the document. It is notice there given that there will be a slowdown. That's your company writing to Panther and the engineer.
Okay.
Now, can I ask you then, please, to turn to the response that was received on behalf of my client from this firm, from Al-Tamimi & Co., I believe, on the 9th of July.
Yes.
And that is at page D905.
905 and click find page.
Can you see that, Mr. Al-Kurdi? Can you see this letter?
Yes, sorry.
Can you click down?
This here I have some problem for opening. 1 second, please. I let my assistant. He will do something for open file. 1 second, please. Parveen.
I do apologise, Your Honour. I think from what I understand, there's some technical issues with getting the e-bundle to work. Hopefully, it'll be resolved.
Go back. Again, please, your question. Which?
Thank you. If I could ask you to look at the 4th paragraph down.
He still needs the document.
As you are well aware.
He still needs the document. He hasn't got the document.
I'm sorry, Judge, excuse me.
It's page 205.
It's page
905, I think.
Oh,
905.
My fault. Page 905. That
In
goes in the little
section
white
D.
box, and then you click find page, and it should come up with page 905.
Okay.
You see, Mr. Al-Kurdi, how are you going? Have you found it?
Yes. Now this Al-Tamimi letter. Yes.
Thank you. Thank you very much. Now you'll see about four or five paragraphs down. It says, as you are well aware, the engineer has, following careful consideration of all circumstances and having consulted with you, already determined the extent of your entitlements in respect of your variation and extension of time claims. The engineer's fair determinations made in accordance with the contract are therefore binding on both parties unless and until revised pursuant to the procedure set forth in the contract. Did you see that? And
Yes,
I'm saying that in this letter, you were being told that the engineer's determinations were binding on you, and those extension of time, all of them, apart from the two that were not, and that were never the subject of any complaint, they were over and done with at that point. Would you accept that?
Okay, I can accept it, yes.
Yes, and you did not trigger any further, you did not complain within 14 days about the engineer's determinations in any formal way, and you didn't take any proceedings, isn't that correct?
I want to see date. One second, please. Let me see date. This 9 July. Okay.
Yeah. So what I'm suggesting to you is that if maybe we could just look a little bit further in that letter on the last page, the third last paragraph. Al-Tamimi says to you, any slowdown of the works, in inverted commas, will, without prejudice to any other entitlement, lead to the issue of a notice to correct, including pursuant to clause 8.6. Further, what you erroneously characterize as suspension would actually constitute an abandonment of the works. This is a very serious issue, which constitutes a clear ground for termination under clause 15.2, and this would in turn trigger Panther's significant entitlements upon termination. And then in the last paragraph, it refers to the payments that were made to your subcontractors because Panther had to step in and pay your subcontractors as it was entitled to do under clause 4.4 of the contract. Now, I have to say to you that this letter was a very clear warning to MESC that a unilateral suspension of works by MESC in an attempt to press its case would be a very, very serious issue. Do you accept that?
We accept it, but this we are never do any slowdown in the site. This paper coming related to our discussion for pushing for will be accepted our extension of time by engineer. But no slowdown in the site. Site going up to last moment, up to last day, up to termination came.
Okay, well, we'll come back to that. But in the meantime, can I ask you to just look, please, at page 230. 230 of the bundle in section B. And right down the end, where it says claims and disputes, on the bottom of the page. Have you found that yet?
Again, computer here, some problem for open documented. I am so sorry. 1 second, please, again.
I do apologise, Your Honour. There was a test done previously, and it had been working this morning, as I understand it. So I do apologise. These issues are arising. See if there's anything that we can do.
Come look this page where this not open. This document. Again, sir, please.
Yes, this is the additional agreement of MESC and Panther as to what should happen if you have a disagreement. Do you accept that?
Well,
this
is
the claims and disputes provision of the contract.
I'm
sorry, Judge.
It's page 230 in the white box, and then you click Find Page, and that should bring up 230.
I'm sorry, I thought you were inviting me to put the question. Excuse me. Are you ready, Mr. Al-Qadi? Can you see it yet?
Yes, I open now. Is this open? Tell me.
Okay, very good. At the bottom of the page, you'll see a clause 20, claims and disputes.
Clause 20, yes.
Yes, and right at the bottom. It says the parties shall seek to amicably resolve their disputes regarding any matter connected with the contract. And then just over the page, it then says, such negotiations shall involve senior representatives of each party. And then the last paragraph says, if the parties cannot resolve any dispute or difference within 90 days, either party may reserve the dispute to the competent court of the DIFC for final resolution. Do you see that?
Yes, I see.
Yes, and you accept that that is a jurisdiction agreement providing for the competence of this court, for the DIFC court to resolve disputes.
Yes.
Yes.
This part of agreement, yes.
Very good. We'll come back to that later. But what I'm saying to you here again is you never brought any complaint about the delays any further. But instead, I think you entered into a commitment on about the 15th of July, 2019.
Yes.
Can you hear me? On about
Yes,
the
I hear you.
15th of July 2019, I think there was a meeting between MESC and Panther where you committed to providing a realistic program for
Yes.
the completion of the project. Isn't that correct?
Which one not correct?
That you met on site on the 15th of July and committed to providing
Yes.
a realistic program.
Yes.
Yes, and we can see that reflected at page 904 of Bundle D.
Yes.
And this is, just can you scroll up, please? This is again a letter dated the 18th of July from Al Tamimi to MESC, where it refers in the paragraph about fifth down to say we're encouraged that MESC met with Panther on the 15th of July and instructed that during that meeting you committed to providing an up-to-date account, etc., and providing the date upon which you considered that the works will have satisfied the taking over criteria under the contract. So that was what you were agreeing to in July, isn't it? That was your goal.
Yes.
And that involved providing my client with a realistic program of completion. Do you accept that?
Of course I accept, yes.
Yes. And you accept that the engineer was entitled under the contract to give you instructions for what was required. Do you accept that?
Of course.
Yeah, that was the engineer's job. And on the 13th of August, 2019, you received such an instruction from the engineer, isn't that right? And I can refer you to the page if you wish.
Okay. Continue. 14 August. Okay.
Sorry, excuse me. I'm sorry. Excuse me, Mr. Al-Kurdi. It's the 8th of August. And it's at page Q. It's section Q 11570. Section Q 11570.
Section Q. 1 minute, please. Q. Section Q, which page?
11570.
11. It's 11. Yes.
Yes. And in that letter, the engineer is saying that the progress on about 4 paragraphs down, the actual progress of works is significantly behind, and if continued at the current rate, further delay will be incurred on the project. The slow rate of progress is causing considerable concern, and on the previous progress meetings, we requested you in accordance with subclause 8.6 to submit your plan and the methodology to complete the project. And that's been over a month ago, has now elapsed, and this constitutes a clear breach of the condition of the contract. And I think what the engineer is referring to here is that you have an obligation under the contract to provide information to the engineer when requested, and specifically in relation to the completion date. What you were all aiming for at this point was to come up with a realistic program of works. Isn't that correct? What was that an instruction, Mr. Al-Kurdi, from the engineer, that letter?
But this section Q 11, this one letter from MISC, not from engineer.
I'm sorry, Mr. Al-Kurdi, I think you may have looked at the wrong letter. It's page 11570. 11570. Page 11570. And have you found it yet?
No, still I am looking. I'm on 155. Again, what page number, please?
11570.
11570.
Mr. Dillon, sorry, I hate to interpose and I don't mean to interrupt your evidence, and I won't be addressing the witness, but I just wonder if the witness is aware of the find tool at the top in relation to the case lines, as it may make things more straightforward in terms of document referencing. I'll let you explain how that works, so that it's still part of your questioning, if you so wish.
Thank you. I think at the top of your page, Mr. Al-Kurdi, you'll see there's a mechanism which says find on the top left. There's a button beside home. It says find. Do you see that?
I try find this page.
And then do you see the find button?
Well, is there someone there who could go into the room and show the witness the top line, the home find view, present notes, download people, and show him how you click on find, and then what will appear towards the middle of the page is a blank box. You put the page number in and you click on find page, and out comes the document.
This is the page. You just click enter the number.
I understand someone's going in now.
Yes, someone's gone there in there.
1150.
11570.
570. Find page.
Okay, now coming. Okay, Naga letterhead. Okay, notice correct.
Yes.
Progress slow down. Okay.
Thank you. Now, the time for completion is noted in this letter as being the 11th of November 2018, and we're now on the 8th of August 2019. And you'll see if you scroll down over the page, the last big paragraph, it says, pursuant to subclause 15.1 of the contract, we hereby instruct you to urgently comply with your obligations under subclause 8.6 to submit a work program and supporting report describing the revised methods which the contractor proposes to adopt in order to expedite and complete the project within 5 calendar days. So this was an clear instruction to MESC. Isn't that right, Mr. Al-Kurdi, from the engineer?
Okay.
Yes, and you had an obligation under the contract to comply with the engineer's requests. Isn't that right?
Okay, continue.
All right. Now, you say on your case that instead of satisfying the engineer, because the engineer, I take it you realize the engineer was never actually happy with what you provided him, was he? Mr. Al-Kurdi, can you?
Yes, I hear you. But what reason? Why he is not happy?
No, I'm asking you to confirm that the engineer was never happy with anything you later provided him, was he?
Sorry, Your Honor, I'm not clear about what the engineer was not happy about providing. Sorry,
Okay.
I'm not sure if the question could be specified.
Very good, very good. Did you provide revised information with a complete program of works to the engineer after this instruction?
Yes, of course. This time we sent the program with a memorandum of understanding. We sent it together.
Yes, very good. So it was the memorandum of understanding that you sent, isn't that right?
With a program.
Yes, okay, very good. And on your case, you say that there was actual mutual agreement. Let's look at paragraph 13 of your witness statement for a second.
Statement 13.
That's at page 283. 283. You probably have your witness statement with you.
Okay, with witness statement with me, yes.
Yes. And you see, you say in your witness statement, it was mutually agreed that the project would be handed over by the 31st of December 2019.
Yes.
Isn't that right? And your case is that there was agreement on the Memorandum of Understanding. That's your case that you're telling the court.
This one we proposed to engineer and the client if will be complete memorandum of understanding will be complete project in the 31/12/2019.
Yes. Was that your proposal, or are you saying there was actual agreement on that?
We sent it. We proposed and will be sent it. We proposed. He asked us how we can complete a project. We answer him. This will be make memorandum of understanding for 2 reasons, and we change payment terms and we send the program. He signs this memorandum of understanding. We proposed and we sent the program under our proposed.
Yes. So are you standing by your evidence in paragraph 13 of your witness statement that there was actual agreement on your memorandum?
Yes. This one.
Or was it just a proposal?
No. This memorandum of understanding we proposed and we do. We give him program actual. We won't complete in this time.
I'm sorry, I have to ask you to answer the question, Mr. Al-Kurdi. In your witness statement, you say there was mutual agreement of that the project would be handed over on the 31st of December 2019.
Right.
I asked you, was that mutual agreement the proposal in the Memorandum of Understanding?
Yes.
And I'm asking you, are you saying to the court that my client agreed to the memorandum?
Yes, he's agreed memorandum and he take it for send it to engineer and he put some comments and he send it back to us. He asked about consultant fees. Yes, but as timing, he is accepted. He is
Okay.
accepted, but he have comments about consultant fees. But he is agree with us about this one, about the program and timing. Yes, he's accepted.
Okay. Let me bring you to page D1245.
Yes.
That's D1245.
One, 3, 4, 5.
1, 2,
1, 2. I'm sorry.
4, 5.
1, 2, 4, 5. Yes.
Yes. So here on the 28th of October 2009, you are sending the subject is the Memorandum of Understanding, and you're saying, please forward this for my client's final endorsement.
Sorry, I am finding 205 this photo.
Mm-hmm.
Is correct?
2019, I'm sorry. Yes. Can you find the document? Can you see it?
The page number is 1245.
Yes.
1, 2, 4, 5. 1, 2, 4, 5. Language. Okay. Now our missed letterhead. Okay. Memorandum of Understanding. Yes.
Yes. And you're sending this to the engineer,
Yes.
asking the engineer to forward it to my client so that it may be signed. Isn't that correct? And if you could please take a look at page 1248, just a few pages on.
1248.
You can just scroll down.
Yes. 1248. Okay.
Yes. And you see there's a signature by MESC, but there's no signature by my client. Isn't that correct?
Okay, because we sign and we send it to him for his sign. We meet that day, we meet in the site and we are agree, will be both party will be signed. He take it this day, we signed from our side and he said tomorrow he will return to us. He is not signed. You say he's not agree. No, he's agree verbal, but he takes this with him and he not signed. And second day, we find message from him for liquid damages our bank guarantee. This what happened.
Well,
yes.
Let's put this in.
He's not signed right. He's not signed right.
Yes.
He take it. He is not signed. Yes, you correct. But he take from us. He take with him. He said tomorrow will be send it back because he have no stamp. And this time we give him by hand in the site.
Well,
we give
that
this
is.
moment.
Let me take you, Mr. Al-Qadi, a few pages back, because let's put this in context. The previous day, on the 27th of October, there was a management meeting. Isn't that correct? So if we move back to page 1242.
Okay. See,
yes?
this memorandum of understanding, we make it 2 times, 3 times, because when will be signed and send it to him, he send it comments to us. I told you before, he is not signed it because he review with engineer and he is stopped. He holds some time related to fees for consultant. He asked who will pay fees. He tried negotiations with us if we can accept it, pay consultant fees.
Yes.
We ask him.
We'll come to that,
how much.
Mr. Al-Qadi. We will come to what the Memorandum of Understanding, what was in it, in a few minutes. But can I just ask you to look at page 1242? You'll see this is the minutes of a management meeting, and you were at that meeting. You can see from page 1244, that you were the sixth named participant at the meeting. Isn't that correct? You were at the meeting on the 27th of October, weren't you?
Yes. No.
Yes. Do you remember the meeting?
Of course, we do. We do many meetings, not only one meeting.
Okay.
But last meeting was last revised memorandum of understanding. This will be done in the first.
Let me slow you down just for a minute. Can you please look at 2.2 in the minute on page 1242? It says that MESC informed, are you reading this? That failing to sign the MOU by all parties will lead to more delays in the project. The project will have an open end and they will not be committed to any completion date. That's in the minute of this meeting, isn't it?
No. This in the meeting. We proposed to him in the meeting. Will be sending the program to him.
Mr. Al-Kurdi,
Yes.
you must be straight here with this court and let us know what exactly you said at this meeting. This meeting records in paragraph 2.2 that you told the Panther that if the MOU was not signed by all parties, it would lead to more delays, the project would have an open end, and that you wouldn't be committed to any completion date. Isn't that an accurate recording of what you stated personally to my client at this meeting?
Yes.
Yes. And isn't it the case that you said if it took 10 years, if necessary, you would not complete the project?
Sir, will be never say we not complete the project. This one only negotiation for will be closed. This one memorandum of understanding. He asked.
Did you, Mr. Al-Kurdi, did you mention 10 years at this meeting?
No, of course no. Where? This nothing. How 10 years? This illogic. How we can will be say 10 years? This only he say, but where we have writing, we
Mr. Resk has given evidence this morning.
This incorrect. This incorrect.
It was indicated. Do you remember this meeting?
Of course, sir. Of course.
Yes.
By myself.
So what did you say?
No, let the witness. Sorry, Mr.
I'm sorry. Excuse me, Judge. Excuse me.
Carry on, please, Mr. Dadi. Finish
My apologies.
What you wanted to say. Please. You were interrupted, and I want you to carry on with what you wanted to say.
Okay. This one and this week before termination. Every second day we meeting in the site, and every second day we have some challenge. He say left, right, like this. This what he attaches in the October 27, 28. Sometimes we not make memorandum for meeting. We not send it later, but every day we are meeting and discuss verbal. But will be never say to him we cannot complete a project within 10 years. This incorrect and illogic. How we will be say like this?
Well, the clause point 2.2, which is the recorded minute of the meeting, says that the project will have an open end and that MESC would not be committed to any completion date. And you've already agreed that that is accurate. Isn't that right?
No, we never say like this. We send it to him program up to 31 December 2019. We say in this date we can hand over project to you. We make memorandum of understanding under this date, under this program up to the end December.
I see. Can I ask you to look at page 1249, Mr. Al-Kurdi, just a few pages on, 1249.
1249.
Yes.
I don't think you can scroll down to it. You have to put it in again.
If you go into the page number again.
Yes, this page 1249. Yes.
Yes, please. Do you see it?
Yes.
Now, this is a letter from MESC on the 31st of October, isn't that correct?
Yes.
And you're writing to the engineer and you're saying, with reference to the above project, we acknowledge the your letter of the 28th of October, and we'd like to bring your kind attention to the minutes, and you'd like the following modifications to be incorporated in the minutes of the meeting. Isn't that right? You see the point 01.
Yes.
Insert a following paragraph after item number 2.1.
Yes.
And there you're expressing your disappointment of the non-response after 1.5 months from
yes.
Panther to the Memorandum of Understanding.
Yes.
And then in point 2, you say insert on point 2, subject to MOU acceptance by the employer after slow progress of item 2.3. Yes. And what you're asking the engineer to do is to record that you will not be carrying out works, you will be not making progress on that item until the MOU is accepted by my client.
Because we are working September and October with verbal accepted by him, he will change payment terms. And all subcontractor, he waiting, he make it approve for September payment. But September payment up to today is not certified.
But you're writing, yes, excuse me, go ahead.
Sorry.
No, you go ahead, please.
Go on, Mr. Al-Qadi.
No, again, what your question is? This letter is our letter. Yes, I cannot say anything writing in the letter. Okay, I accepted letter. I try explain to you what happened in that discussion.
Yes, thank you. And so it's clear then that on the 31st of October, there was not yet agreement. Isn't that right? There was no agreement on the memorandum.
That day still not signed. Yes.
Yes.
Verbal accepted by him. We working 2 months, September full and October full under verbal approval. We start negotiation with him. He test us and will be do so good progress in this 2 months, September and October. We are start, as if you see our letter, we send it to him in 11 September. We send it the Memorandum of Understanding. We working full 2 months, September and October, under verbal approval from him. Related to our negotiation, what he want added some condition, he want put something like this. And 2 months going without he certified, because in this our Memorandum of Understanding, we change our payment terms. And everybody, all subcontractor, he waiting his payment for progress moving, but finally he not signed.
If I could just ask you to look at paragraph 11 of your own statement, page 282.
Page 282.
It's your witness statement.
Your witness statement, paragraph 11.
In my statement, tell me, yes, which...
paragraph 11.
11, yes.
And in that statement, you say that you made it clear to my client that you would complete the work, that MESC would complete the work.
Yes.
Now, I have to say that the record of the meeting on the 27th of October and your letter on the 31st of October was quite the opposite. And it was an indication that you would not complete the work unless the Memorandum of Understanding was signed by my client.
Okay. We complete work, we try complete work, I tell you, under verbal approval. And that time, yani, when my statement here, how we are working September and October, we working under approval, verbal approval. We trust him. We try make as friendly, and for what we make memorandum of understanding. If we don't want yani, move together, if we don't want complete work and handing over project, for what we make memorandum of understanding.
I see. Can I ask you to look then again at 1250, page 1250? And this is a letter that you wrote, or that MESC wrote,
Yes.
on the 3rd of November.
1250, okay.
Yes. And here, if I could just ask, can you find that, Mr. Al-Kurdi? Can you find it? It's page 1250.
I find it, yes.
Thank you. And just to go to the end of the last paragraph of that first page of the letter, you're saying the employer and the contractor reached a mutual agreement for the best interests of the project on the 27th of October 2019. So in this letter, you're saying that the agreement you say was reached on the 27th of October 19. Is that when you say this verbal agreement was reached?
No, that one we sign and send it to him. Our copy with him with our signature. For this we say like this.
But it was quite clear at this time, wasn't it, that my client was not signing the Memorandum of Understanding?
Habibi, he not signed for what reason he not signed? He put different reason. But we in the meeting we are accepted. We as he give verbal approval and we sign and we give him. He keep it with him.
Yes. Well, the reasons why I have to say are that what was being proposed by you was unacceptable from my client's point of view.
Acceptable?
And you knew that.
What not acceptable? I not understand. Please again.
Mr. Al-Kurdi, what do you think the reasons are why my client refused to sign the Memorandum of Understanding?
Yes.
Do you know why my client refused to sign the Memorandum of Understanding?
He not signed because he have his plan. He have offer plan in his mind with his engineer. He when will be meet, will be discussed, will be approved, will be he send it to us comments, and he sharing us this memorandum of understanding. We not do alone. We do together with him, and he added something. But finally, he is not signed. Really, we are not understand why he takes this action. Up to now, I not understand. We is accepted. We are accepted everything. And when he discuss about final stage, last moment he speak about consultant fees, we say, yes, we can share, we can do something. We discuss verbal. And we give him. And he sharing us. Yeah, this memorandum of understanding, we share together, two party, we do this page. This memorandum of understanding. Okay.
Well, look, we will be moving away from this subject soon, but I must ask you, please, just so it's clear, and perhaps it'll ring a bell with you. You may remember the reasons when you see the letter on page 1252, which was written on the 3rd of November 2019 on behalf of Panther by this firm.
1252.
1252.
1252. Yes, Al-Tamimi, yes.
Yes. And you'll see in that we refer to the Memorandum of Understanding that you have persistently been requesting that Panther executes for several months. As you are well aware, the respective rights and obligations of both Panther and MESC are as clearly set out under the contract, which is fully binding on the parties. Regrettably, the MOU is a crude and baseless attempt to deprive Panther of its clear and legitimate entitlements and causes of action that it has against MESC, arising out of MESC's numerous, serious and substantiated breaches of contract, not least in respect of MESC's culpable delays. However, we are particularly concerned to note your position that completion of the works by 31st of December 19 is contingent upon Panther executing the memorandum. For the record, we note that a completion date of 31 December 2019 is already more than 12 months after the time for completion and is almost as long as the build period under the contract. Further, the engineer has determined that MESC has no entitlement to an extension of time in respect of any of this delay. It therefore appears that you are seeking to use your own failures to perform, yes? And
Yes.
as leverage
Yes.
to absolve yourself from liability for your breaches to the obvious detriment of Panther. This is an entirely unscrupulous and untenable position that offends numerous pervasive principles of DIFC and to the extent applicable UAE law and will not be tolerated. And then over the page it says that Panther, accordingly, Panther will not be executing the memorandum under any circumstances. However, we take this opportunity to remind you that you remain in clear breach of the contract and your resultant liability continues to accrue. And it suggests that you focus your efforts on completing the works without delay. And I have to say, Mr. Al-Kurdi, that one of the key things in the Memorandum of Association was that you wanted a clean slate on all of the delay. You wanted my client to give up the delay damages and everything, didn't you?
Okay. I can answer you. Excuse me.
Yes.
Yeah, we
please
can hear
answer.
you. We can hear you. Yes.
We can
Yes,
hear you.
okay, you
Please
can hear
answer.
me. Okay. That day, 31 December, not he say he is not accepted. This not proposed by us, and nobody he can complete the project before this day. Because now this day we propose together what logic and accepted by all what we need time for complete. Yeah, this date and not from only from us. He asked engineer and will be all party. He accepted. We need this time for complete the project. But when will be he is not signed. He's not signed for. If he will sign, yani he will accept it if all delay come by him. And this what true. What true? His engineer, this Mustafa Rizq, all delay project come by him. When he will sign, of course, means he is accepted or delay happened by him. For he cover himself, he try not sign. But when if you ask him when he can complete the project, nobody can give him this project before this time. Yeah, this time 31 December, this what logic and what acceptable any contractor he can do and handing over a project.
But by
Now-
this time, but
now
do you
in this
accept,
data-
Mr. Al-Kurdi, that by this time there was already very extensive delay on the project?
Okay, delay project by owner, not by us. Delay project by owner. We have enough free zone, and we already have everything with you. We are ready for one by one. A project delay by client, by him, not by us. This proposed day 31 December. We accepted both party. We are proposed what logic time, and already he accepted verbal, and we signed. We send it to him. But finally, he have his plan, and his engineer, he don't want to accept it. He go to his plan.
Very good. And do you accept that when you received this letter on the 3rd of November,
Yes.
and when the engineer wrote to you on the following day, on the 4th of November, that you had already received many, many complaints from my client that you were in breach of contract. By this stage, by the 3rd of November 2019 and the 4th of November 2019, you had received many complaints, including the one we opened earlier from the 8th of August 2019.
Yes.
Do you accept that we had complained a lot?
We are not accepted, but what we can do, yani, for what my question, yeah, this only paperwork, he can put what he writing and he send it. Of course, I not accepted. We are not accepted, but finally, if I not
didn't.
accepted,
I'm sorry. Maybe my question was a little confusing. I'm not asking you to accept that the complaints were that you agreed with those complaints. I want to ask you, can you confirm that by the 3rd and 4th of November 2019,
yes,
you had received a very many complaints from my client that you were acting in breach of contract and that the delay was unacceptable?
of course, I am not accepted. And 3rd November for us, this day, liquid damages our bank guarantee. From that time, khalas, this day final between us and him. We are not respect each other because he liquid our guarantee. He troubling us and khalas, no more. Yani what he writing in the paper, we have no any more discussion. Will be stopped everything.
I'll just ask the question one more time. I'm sorry, Judge.
I'm so sorry. Ask the question, and then I'd like to intervene for a moment.
Yes, I'll just ask the question one more time.
Yes.
Let's forget about the word accept, because I can see that that's causing difficulty. Did you receive a number of complaints and letters from my client and from the lawyers from my client that you were in breach of contract because of the delay on the project before the 3rd of November 2019?
3rd of November 13, yes, this letter come from El Tamimi, but what will be do? What will be do this letter coming about what? Because khalas, this 3rd, I told you 3rd November will be nothing. We are not accepted anything more from him. Because in 31 October, what you show me now, this day, last meeting, must 2nd day, he will move, but he have his plan, he have his off plan. He go to bank and he send the guarantee, khalas, no more discussion. I not accepted anything from him. For what? Yes. We are 2 months, please, let me complete. September and October, 30 day, 60 day, we are discussed and modified this Memorandum of Understanding. What I want to say about this 3rd November, you send it this letter from you, from lawyer, or from him or from anyone. Of course, I not accepted any more letter because must will be forgetted everything and sign Memorandum of Understanding. This Memorandum of Understanding take with us 60 days for completed both party. And the last moment you tell me now, you ask me about letter in 3rd November. 3rd November, no more discussion. This letter come from, you tell me I accepted. Of course, I not accepted.
Right, I think that's enough on that topic. Now, it's 6 o'clock in Dubai, and progress has been slow. The court for in-person cases in Dubai, of course, usually rises the latest at about 4:30, and we have to bear in mind that the court staff. And I don't think we should continue at this point, but we should adjourn over till tomorrow. Now, Mr. El-Kurdi, would you listen carefully to what I have to say?
I not get it, you, sir.
You didn't hear me?
Yes, I hear you now. I hear you.
You can hear me now. Good.
Yes.
Now, what I'm about to say to you, I say to every witness who is in your position, namely,
Yes.
you haven't finished giving your evidence. We're breaking off now and we're going to continue tomorrow.
Yes.
Now, in these circumstances, you must not talk to anyone about the case. And in particular, you must not talk to your lawyers. Now, your lawyers know perfectly well that is the rule, and they wouldn't dream of wanting to talk to you about the case. But you mustn't volunteer any comment at all to your lawyers or to anyone about this case. Do you understand?
Yes.
You can pass the time of day with your family, of course you can, but you mustn't talk about the case to anybody. And we will resume tomorrow at 12 o'clock noon time, Dubai time, and we shall continue with your evidence till we've completed it. Have you understood?
Yes, okay.
Thank you very much, Mr. Al-Tadi. We will continue tomorrow at 6. Now, I'll just have a word with learned counsel, both learned counsel, about our progress and the like.
Okay.
Do feel free
Thank
to
you,
leave.
Mr. Al-Kadi.
Do feel free to leave if you want to. If you want to stay listening in, that's fine. But if you'd like to get away, that's no discourtesy to the court. You're free to go.
Thank you very much. Yes.
Now, we agreed when we had the PTR that the evidence, both factual and expert, would be completed in 3 days, Monday, Tuesday, Wednesday. We'd have Thursday just as a reserve, but very much as a reserve, and it would be written closing submissions. Now, it's important that we do our utmost to finish the evidence on the end of the 3rd day. Now, sometimes things get in the way, and that's why we have a contingency on Thursday. But I would like both sides to do what they can to complete the factual and expert evidence by close of play on Wednesday. Is that understood? And we have a number of witnesses to come after this witness. They're all expert witnesses. I did emphasize when we heard the PTR how important it was that the witnesses be trained to be able to use the case lines in order to find the documents. Once we'd explained everything carefully to Mr. Alfredo, he had no difficulty. But please, can you make sure that the other witnesses will be able to go straight to documents that are mentioned? If the page is given, then they use the find page facility. That's all I have to say until tomorrow, when we shall resume at 12 noon Dubai time. Thank you very much.
Thank you.
Thank you, Justice. Thank you.